Okay. What's up, guys? Welcome back to Kitchen Court Cases. If you found the stream, I barely did. Not quite, honestly, not sure. Uh, I don't know. I don't know. What's up, though? I hope you are having a good evening. Yes, if you are just getting here or you've got, I saw the, now I'm all confused. Regardless, welcome to Kitchen Court Cases. We watch court in my kitchen. My lighting now has messed up. There we go. It's back. Allie B from Tennessee is here. Um, I hope you are having a good day. I see Jonathan Hart. I see Hector who's going and coming back. That's great. Beverly Bradford made it. Did Courtney make it? She made me laugh earlier, which was great. I love to see that. We are going to be watching some pretty interesting court tonight. Bitches against bullshit. Sit in the back of class. Listen, I loved your comment the other night on the that dental thing. I was like, yes, somebody watched it and listen. Hi, Cherry B. I hope you're doing well, guys. Like I said, we have a bunch of court to watch, and I have a couple things to do tonight, so I had to start early. I'm glad that you're with us. We have Larry. You can step down for a couple minutes, and we can also just everyone here is probably subbed. Um, they what are we gonna do? Oh yeah, we're watching court. Oh, yeah. We have a TPO hearing, and it's a weird one, you guys. I'm not even sure what to make of it yet. We will have to figure that out together. I watched parts of it, and it was a little bit confusing. But let's see how we do. Give me a few minutes to make sure that the stream is working properly. I gotta take off these shoes. I was wearing high shoes in honor of Allie B, which I fixed everything for, but the reality is everything's at lower levels. Hi Valentino. I hope you're doing well. Um, oh, Beverly, it's storming where you are, and I wish there was some rain too. But Allie, let me show you these shoes. Aren't they sweet? Look at the back of those. No, this is not two guys getting a TPO. Um, this is a lady. She's at the top here. This is a lady. I was like looking, I was like, is it? It's a lady. These shoes are impressive. And but Nana does not like it when I wear them inside, to be frank. Those are whore heels. They're not hooker heels. They're whore heels. Anyways, let's get started. Um, But remember, you can be a hooker and a whore in here if you want. There is no shame in hookering, by the way. Hookers work harder than a lot of people. I'm going to tell you that right now. You find me, yeah, I could tell you, yeah, they work great. Uh, that's what I believe. Hi, Jay. I hope you're good. Uh, the difference between a whore and a hooker is that a whore does it for free. But okay, let's get going and then we'll see how we do.
That's also one of my witnesses here today.
All right, have you, Mr. Harvey?
Oops, we started a little.
Are you there? I need you to start your video. All right, there we go. Okay. All right, sorry for the back and forth, folks. Just trying to move people out of court who have finished their business here. All right. Miss Stokes, you were telling me that you believe that Mr. Harvey was using his home surveillance to figure out when you and your kids were coming in and out of the house. Why do you think he was using surveillance? How did he tell you that? How do you know that?
He made the comment when the police came out on the 29th of this year that he would continue to watch.
Usually we like a month. The 29th of this year is great, but that only narrows it down to like 7 different months. Well, no, 6 because we haven't had the 29th of July yet. So, yeah, I had to run and get the red flag. Guys, please clock in for your shifts. Regardless if there's monetization on this video or not, which there is virtually never monetization on my lives. That's not the point. So I don't worry about it. But clocking in does help. I love that. So this is weird. Also, Kate pants their mom. Thank you very much. You were correct. Those are fuck me heels. Fuck me heels. But that is really a woman. But thank you for becoming a member. That's awesome. We clock in for our shifts around here by hitting that like button. If you don't like the video or me, you are required to still hit the like button, but you are entitled to a rebate on that like, which there is a form that you fill out and you mail that to me in Canada. And there's a processing period, but I will refund your like. Uh, but it's about 90 days. So just so you know. Hi, Cachette.
Watch my home. And then he conveniently had another camera installed facing my home.
How could you see that? Where is it?
It's over his driveway, which faces the direct front of my house. Mr. Harvey has been caught by my witnesses that are present today taking pictures while I was not home of my other vehicles outside their plates. I've filed reports. I've gone so far as to reach out to the detective for DeKalb County criminal investigation because this is something that has been ongoing for over a year.
All right, so I do want to make sure I understood. So the first time the police were called was back in June 6, 2022?
2022.
So it's how many times would you say since then through June 29th that he's called the police regarding cars on the street?
I would say at least 3, if not more times, because I have a total of 5 police reports. And every time that he's called, I've had to also have a report done for harassment.
All right. How many cars do you have?
I have a total of 6.
Just you personally, or you and your husband together?
Me, my husband, and my daughter.
Okay. So the family has 6 cars.
Correct.
Okay. And just so I can maybe understand a little better, where do you park your cars, or do you utilize your driveway?
I have 2 cars parked in my driveway, and the other 4 are parked on the street. 2 are parked in front of my home. 1 is parked, and the other 2 are parked in front of my other neighbor's homes.
Is one of those Mr. Harvey?
It's not parked directly in front of his home. It's across the street from his home. So the neighbor that's on my side, it's parked between my mailbox and their front yard.
Okay. All right. Are all of them parked on your side of the street?
With the exception of 1.
And where's that one parked?
It's parked in front of my neighbor's home, and it's close to their driveway.
Is it near Mr. Harvey?
It's on his side, but it's a definite good 30 feet away from his front door.
Okay.
It's
from his front door or from his yard? I'm not making a judgment about where you're parking. I'm just trying to get a picture of what's going on here.
Okay. It's parked directly in front of their front door.
The other neighbor.
My other neighbor.
Okay.
And that's
weird. That's a lot of cars, you guys. I'm going to be frank with you. Like, that's a lot of cars. That's a lot of cars. Also, if your driveway isn't big enough for that, like, you got to sort that shit out. You got to have a friend that has a driveway where you can, like, I've been a driveway for people because I have a friend who has a car business, but that's different. He's wholesaling cars, slanging cars. Like, that's not this. Are they ever changing cars or the same cars? You just like park. Why would you? Okay, I'm confused.
Also one of my witnesses here today.
All right. Have you, have you communicated to Mr. Harvey that you don't want him talking to you?
Correct.
When was the first time you did that?
This was done last year.
What did you say?
I simply told him I did not wish to communicate with him anymore, as he is not the homeowner. I spoken to the homeowner who he's alleging is his wife. She is his ex-wife. She is not his wife. She's his ex-wife. I've spoken with her. When I spoke with her last year, we had no issues with regards to parking. Mr. Harvey is doing this when Meg or Magaline is not available, meaning she's not home, or she just doesn't wish to be bothered, because she does not come outside when the police are called.
Okay. So you told him about a year ago you didn't want to talk to him anymore. And how many times would you say you've been outside since you told him that where he has tried to talk to you?
It's been at least 30, if not more.
Does he come on your property, or does he just holler from his?
He has walked to my driveway.
And when he does that, do you ignore him?
I do.
And have you recommunicated that you didn't want to talk to him ever?
I've done that in the presence of the police.
Okay. And when's the last time he spoke to you while you were outside without the police there?
Just the other day.
After the filing, after he was served with the protective order?
Correct. Just yesterday, as I was coming in with my family, because one of my husband's vehicle is not physically present outside, it happens to be at the repair shop. Mr. Harvey was unaware that my husband was present. And no sooner than my family started going in the house and I happened to be the last one closing up my car, here comes Mr. Harvey. And he's sitting out there watching me get the stuff out of my car.
All right, what did he do? What did he say to you? Yes.
He doesn't say anything currently. He just stands there and stares. My daughter, he's standing on his front porch. Drinking beer. Then the week before last, my daughter decided she was going to wash her car that she got for her birthday in front of my garage.
These people's love language is cars. Okay, that's obviously what's going on here. They give each other cars for their birth. Like, this is insane. You have 5 cars and you purchased another car for your child for her birthday? That's confusing to me. That's confusing. Also, I just am thinking to myself about how many of my neighbors might want a TPO against me if this is the threshold that we're living at. Because, for example, yesterday was a very, very big chase day. There was like lots of live chases that I was watching, and I was yelling. I was like, oh my God, like just freaking out. And at one point, one of my neighbors was like, is everything okay? And I had to like embarrassedly explain, like, yes, it's totally fine. It's a police chase in Los Angeles. Like, I'll go inside. But, in the summertime, I'm worried about how many of my neighbors are like, we got to get a TPO against that lady. She's standing on her deck all the time. And I'm like out there smoking a joint, like thinking. And they're like, she's just watching us. Like, I probably look like I'm watching them. I'm not. I'm just standing outside. Like, I'm seriously a little bit perplexed. I'm a little concerned. Oh, dear.
Garage, which does not impede Mr. Harvey's garage in any way. And I left her outside to start washing her car. And Mr. Harvey decided he was going to come out and watch her wash her car, to where my daughter felt uncomfortable that I had to come back out and sit with her while she washed her car.
Where was he sitting, on his front porch?
He was with his buddies on the front porch. So now you're having other people sit out and watch.
Okay. How old's the daughter? That's the first question we need to establish right away. She's over 16, likely because they bought her a vehicle, I would hope. So I'm going to actually guess hopefully over. What the hell, y'all? First of all, if I am outside washing a vehicle, there is a reason. And it is because I want people to be looking at me. It's not because I want the goddamn car clean, lady. I don't know what world you live in that you go out there and actually wash a vehicle to wash it. Go to a car wash.
He's had friends over in the last couple of weeks that have all tried to speak and been ignored.
Trying to speak to you?
Yes, me and my family.
And what did they say?
Hey, how you doing? Hey, you over there.
Sorry. I mean, I'm outside yelling. I sound like I'm in distress. My neighbors are really going to get a TPO on me. This lady's neighbors are like, hey, lady, how are ya? Seeing you in a while. It's summertime. We're outside again. Hope you're doing well. This is so weird to me. This is so weird.
And he's standing right there. If you know that you have a TPO and your acquaintances should not be speaking to me, why are you standing there allowing that?
All right. Ms. Stokes, did you have any exhibits you wanted to introduce or?
I do.
All right. And you've sent them in?
Yes, I did.
Larry
Clerk,
Beavers
do
to the
you
front,
see any?
please.
Yes, ma'am.
All right.
You want me to do number one?
Sure. What type of exhibits are these, ma'am?
I have the 2 police reports. The first one would be June 29th of this year after the TPO was served. Mr. Harvey made the statement he was served on the 28th to the officers. And you just stated he was served on the 29th.
Well, that may be when it was filed into the, let me look at the service. I'm sorry, I may have.
Well, so you guys, is she flexing that ring? Is that a ring flex that we're watching up there?
All right. Well, anyway, go ahead. I'm not, you can, if you want to tell us what you want us to look at, we can pull up the exhibit.
So on the 29th, Mr. Harvey was served again after taking pictures of my vehicle and disregarding the TPO with communication. A sergeant came out.
Is there something you want us to look at? We're trying to pull up the exhibit.
Okay, it would be 2 cards on that date with the reports on them.
Larry, no, I'm not into the gummies on my phone.
Correct.
Okay. All right. So this is just, those are the folks you spoke to?
Correct.
Okay. All right. Do you have anything else you want us to look at?
I believe I submitted another exhibit.
Larry Beaver is fired. I had to step in.
I submitted it with my original TPO request.
Also, welcome to everybody
Which would
just
be
getting here.
The phone
Also,
calls.
hold on. Lady, I'm speaking. Kimberly, let's go. You're making me laugh. That's super funny. Also William's here, I see. And who else was here? Oh, Craig was here and a bunch of other people. Oh, Jerry was here. That's right. Hi guys. I hope you're doing well. We're being a bit early today, but this is a fucking great case already. Also, oh no, I have not been into the gummies again. That's what it was, William. Not yet.
From Mr. Harvey.
So these are recordings?
Hi, Trish.
These are not recordings. These are screenshots of the calls that Mr. Harvey made from Miss Magdalene's phone and his own phone.
All right, Madam Clerk, do you see those? Okay, is this what you were talking about?
Correct. After,
And go ahead. When were these? It says Tuesday, but what day
okay,
is that?
that would be the 6th, June 6th of 2023. And then after the police left, Mr. Harvey made another attempt at 1:11 in the morning on the 7th to contact us again. After the
Okay,
police,
and this is, I'm sorry, this is came up, this is the phone number you have associated with his wife or ex-wife, is that correct?
correct.
Okay, and was this from this screenshot from your phone, or did you say it was your husband's phone?
This is my husband's.
Okay. All
That's
right.
not admissible.
Is there another?
You're telling me that you're going to admit that's triple hearsay. Okay, you're admitting a phone record of not your phone, of a phone call from not the defendant's phone. That's crazy. Also, William, I'm what they call an ethical slut. So I don't wreck homes usually anymore.
Exhibit?
Let's see, what other one I sent? There should be a P2. I know a lot of my exhibits didn't go through.
All right, what is this, please?
Okay.
Can you scroll so we can see the top, Madam Clerk? I'm sorry.
Cellulite yoga pants. Cellulite yoga pants to the front, please. We need to speak. I noticed the text message here that says, "You guys are now blocking our mailbox. Can you please move your vehicle?" Did you just not say that you sent that exact same text message recently to your neighbors? Are you one of these people?
What is this, please?
Okay.
Can you scroll so we can see the top, Madam Clerk? I'm sorry. So what is this?
If you scroll down, no, I'm sorry, enlarge and scroll up. The space in the back.
Is that a lake? Hold on. I gotta go up to my big TV. Here's my big flex. I have a big giant TV. It's on giants. But I believe that's a water picture. You guys, is that a water picture? I believe that's waterfront. Are we talking about waterfront people here? This is DeKalb County, Georgia. Now, I live in Canada, land of the lakes, but is there a lot of lakefront in Georgia? This is crazy. Also, yes, Jonathan, thank you. Objection Foundation. Did you take this picture? Was it altered? When was it taken? Et cetera, et cetera, et cetera.
No, I'm sorry. Is this this looks like text from somebody? Who's it from?
This is text of Mr. Harvey and my husband prior to Mr. Harvey contacting the police on back in 2022. The reason this was submitted was for the picture as well as the text. The back of the fence is where I was located on my other neighbor's property on 4th of July. at a family barbecue that they had. Mr. Harvey was looking through the fence this whole entire time until his family member, my neighbor's family member, said something, and Meg said something to Mr. Harvey about being a pervert and peeping through the fence.
Okay, so that's why you submitted it basically for the picture.
Correct.
Okay, you got to be careful with wooden fences and glory holes because splinters are a real thing, Hector.
Okay. All right, is there another exhibit?
No, I don't believe I submitted anymore.
Do you see anything else, Madam Clerk?
They're all just like missed calls or declined calls.
Okay.
You want to look at those?
I mean, if they're duplicates, I mean, did you submit more than one screenshot of calls?
Yes, I did.
Okay. Yes, Madam Clerk, I'd like to see them. Is this all from the wife's phone number or ex-wife's phone number?
So not the respondent. This is so perplexing.
23. These are 23.
Okay. Oh, yes, you did say that. Okay. All right. Thank you, Madam Clerk. All right. Mr. Harvey, you can, if you have any questions that you want me to ask Miss Stokes, you can tell me what they are and I'll ask her. This is not the time for you to testify. This is a very difficult concept for a lot of people who aren't attorneys. There's a time for testifying and there's a time for asking questions. So if you have specific questions you want me to ask her, I can do so. What are those if you have any?
Okay, that's because she said so much, ma'am. I think somebody went out. Are we still there, ma'am?
Yes.
Okay, she said so much. I'm trying to remember half of this stuff, but let's go back for what I remember. The last photo she just sent you of the boat in my backyard.
Excuse me, I don't want this to be testimony. Do you have a question you want me to ask her?
Right. The question is, ma'am, on the top of that text, it said, I'm done. Can you ask her who sent the text or who said they're done?
Okay. She wasn't introducing it for the text. She just wanted us to see the photo to explain about the fence, but I will ask her, ma'am, who sent the text?
The text was done because at that time, my husband was kind enough to cut the backyard for Mr. Harvey and Miss Miles while they were away on vacation.
Okay, thank you. Ms. Harvey, you have anything else?
Yes. And my next question is to Her Honor is, what's my wife's phone number?
Larry.
All right. Ms. Johnson, do you have an announcement that I can put the parties in the waiting room if necessary?
I did send over to you, Judge, position 11. Thank you. A consent order in that matter.
Okay. Thank you so much for letting me know. I have it. I just saw it.
Okay, great. And I just still working on 14. The respondent stepped away from the camera, so I'll keep you posted on that matter.
Thank you so much, Ms. Johnson. I appreciate it.
You're welcome.
Okay. Ms. Stokes, so Mr. Harvey wants to know if you've memorized his wife's phone number. If you don't know, that's fine.
No, I have not.
Okay, thank you. All right, Mr. Harvey, anything else?
No, ma'am.
Okay. All right. You can mute yourself again, Mr. Harvey. Okay. Ms. Stokes, actually, this is a good time for me to go ahead and bring in this party that reached a consent agreement and review it with them. So I'm going to put you all back in the waiting room and then we'll bring you back in. And just to let you know, Ms. Stokes, the next thing I'm going to do is ask you if you have any witnesses ready to go. Okay?
Okay.
All right, so y'all are going to go to the waiting room. Thank you.
Hold on as I pull the curtain and I get the rest of this hearing. Don't worry, we've got it. The judge was looking for any reason. It was like the lawyer was part of her dreams there. She was like, you want to know her what? Like, the judge sometimes in here is just a little crazy. Nice to meet you, Kate Pants, their mom. Is it Kate Pants? K8? Anyways, thanks so much for being here and joining the team. Make sure to clock in/out for your shift. Clocking in is hitting the like button. Clocking out is making sure that you hit the like button.
All right, so we're back. Miss Stokes, do you have a witness you wish to present?
Yes, my witnesses are on Zoom separately.
Okay. Who's the first person you'd like us to look for?
You can look for Maurice Stokes.
No, not a quick night. We have another hour and a half plus, just to be frank with you guys. Yeah, at least an hour and a half, probably. Hi, Taria.
Okay, can we find Mr. Stokes, please?
Yeah, I'm bringing him in now.
Thank you.
And the other witness is not logged in anymore.
Okay, I'm gonna see if I can get him to log back in.
All right. All right, Mr. Stokes, if you can unmute yourself, please.
You know, William, I bet that your wife doesn't wish that you could last an hour and a half. She more thinks or wishes that you'd spend an hour and a half paying attention to her. Your dick doesn't need to be included. There's a little tip. Just the tip.
Good afternoon. How are you?
Thank you. Good afternoon. I'm good. Thank you. Mr. Stokes, I'm going to go ahead and swear you in. Can you please raise your right hand? Do you swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right. Thank you, sir. Mr. Stokes, can you please tell me your full name?
First name is Maurice, last name is Stokes.
All right. Mr. Stokes, you're here as a witness today. Is Miss Ryan Stokes your wife?
Correct.
Okay. And this is a petition for a stalking protective order against Mr. Rick Harvey. How long have you known Mr. Harvey?
I think I'm muted again.
Okay, nope, I heard you, but then now you're muted.
Okay.
All right, there we go. So how long have you known Mr. Harvey?
Say maybe 4 years. Since I moved down to Georgia.
Okay, you're muted again. You've muted yourself again. Okay. All right, Mr. Stokes. All right, your wife has filed this petition alleging acts of stalking by Mr. Harvey. What is your personal knowledge about what's been going on?
When she brought it to my attention the first time, I really didn't see that though to be true. So a couple of times I took it upon myself to do my own little investigation to come to find out that actually what she was saying was actually accurate.
To do my own little investigation, did he just say? Also, whose birthday is it? There is a very... Listen, I have ADHD. I leave my Christmas tree up for a really long time because I just love Christmas. But there's like it's a limitation on a happy birthday sign. Unless the person really likes, and then I'm okay with it.
There was times where she would come into the house, and immediately after her coming in the house, or while she's coming in the house, he's opening the garage and just kind of just staring there, kind of creeping her out, which I found to be a little disturbing. Especially since he lives with a young lady.
All right. What else?
I believe this has been going on for quite some time, I believe.
So
When I
I want
first
to,
met Rick,
I'm sorry, Mr. Stokes, I want to know what you have witnessed personally, or not so much what your wife has told you, but what you, like you said, you've seen yourself. That's kind of what we're talking about. Okay.
I've seen her actually following her. Like the moment she comes in from work, he's opening his garage, coming out, trying to make conversation. She's really not paying him too much of any mind. To the point where I've asked Rick to kindly leave her alone, and he still continues to engage in conversation at that point. Now I know somebody.
Do you remember when you asked him to leave her alone?
I believe this was a while back, maybe around, wow, to give an exact date, I would say maybe last year sometime in 2022.
Okay.
And just recently in June, after receiving the phone calls of him constantly calling me while I was at work.
Okay. So you asked him to leave her alone sometime in 2022, but then also again recently last month.
Yeah.
And when you asked him to leave her alone, what did he say?
He didn't have any. He didn't have any comment. He didn't really say too much. He was quiet.
Okay. All right. Have you witnessed anything else?
Besides him stalking her at this point, no, not really. Just the matter of her coming in, him coming out constantly. It was one day where we switched cars. And because normally she drives one of the other cars, which is her favorite car, and I happened to be driving this car this particular day. So the moment that I drove up and pulled into the front of the house, Rick actually opened the garage and came out, thinking that it was her driving. When he found out it was me, he closed the garage and immediately went back into the house. And that's when I kind of caught on to what was going on.
Okay. Have you seen him speaking to her after he was asked to leave her alone, either by you or her?
Come again, I didn't hear you clearly.
Have you seen Mr. Harvey speaking to her or trying to talk to her after he had been asked not to speak with her?
For the in reference to the TPO, or me verbally asking him that?
Either you asking him not to, or she's asked him not to.
Actually, after I asked him to not speak to her, he continued to speak to her. The day that the incident happened, when the police was called, yeah, he was engaging in conversation, or trying to engage in conversation with her. So it's almost like he kind of waits until, I'm at work because I have set hours. So he kind of knows when I'm home, when I'm not home. Because just recently, I actually changed my hours to be home in the evening with the family.
Okay. All right.
Hi, Harmony.
Is there anything, I've heard about the police being called. Is there anything that you need to tell me about that?
Yeah, he actually, what did he say? He mentioned he will continue to call the police because we were not being neighborly. And that in fact we were.
Okay. And what was he saying he was calling the police for?
Just to be a jerk. Words out of his own mouth.
He told you he was calling the police just to be a jerk?
Correct.
Okay. Ms. Stokes, is there anything you want me to ask your witness that I haven't about his personal knowledge of what he's witnessed or heard?
You can ask my witness how many times he's been on the phone hearing Mr. Harvey's interaction and the words that he's been using towards me.
All right. I'm sorry. And actually, you can ask him the questions yourself, as he's your witness. So are you, but I want to make sure I understand. Are you asking him if he's overheard conversations that you've had with Mr. Harvey? Or conversations he's had with Mr. Harvey?
That if my witness could explain to the court how many times he's been on the phone.
My witness, Honey Poo. Oh, sweetie poo, honey poo. That's a throwback to an old case. I say old like that, like I've been doing it for so long. That's a throwback to an old case that some of the 1K club will remember. Um, Sweetie Poo. Oh my gosh. This is nuts. It's weird. She was flexing before with her rings, her is it Timu or Temu? We don't have that in Canada. Or maybe we do and I just don't have it. These are the worst neighbors. Can you imagine these being your neighbors and you like get some papers in the mail and you're like, "What? I'm stalking her?" And you weren't? Like, could you imagine how weird that would be afterwards? You'd be like, "What? Oh, Ray Bay. Craving melons." There could be many reasons for that.
And been privy to hearing the conversation that Mr. Harvey is trying to engage in.
I understand your question now. There's been numerous times I'm overhearing this this conversation, me being on the phone because I'm at work. So if I had to count on my hands, I will probably need forearms. It's been
Okay, so are you talking about you're on the phone with your wife while she is outside and you can hear Mr. Harvey hollering? Is that what you're saying? Okay.
That is correct.
And what do you overhear?
Just him, what did he say one day that really rubbed me wrong?
I don't know if it rubbed you the wrong way. I wanted to say a very special happy birthday to baby Pork Chop. Officer Pork Chop, did you say that your daughter's turned 19? That's so exciting. Congratulations. Um, these people are crazy. This is fucking nuts. Like, not only did the court have to waste their time on this, I had to waste my time on this. Although it's very good fodder for our evening, but still, like, seriously, these people, it's crazy. Cherry Bee, how was your shower? Do you do cold showers ever? Because sometimes I like to do a cold shower, but usually when I think that I want to do a cold shower, I don't. I don't. I don't want to. I don't actually want to.
Wait, what did he say? He said something about there's been plenty of times. One time I did hear him saying something about the cars. The cars impeding the driveway. Cars were not impeding the driveway. They were parked where they should be parked, away from his driveway, not impeding the driveway, and making that an issue. So a lot of the conversations that were had were pertaining to the vehicles that was in the front that I've overheard.
Okay. All right. Okay. Ms. Stokes, do you have any other questions for your witness?
No, I don't.
Okay. Mr. Harvey, do you have any questions that you would like me to ask Mr. Stokes?
No, Your Honor.
Okay.
Yes,
All right, Mr. Harvey. Okay.
One question, Your Honor. Can you ask Mr. Stokes how many times he cut my lawn and which days?
I'm not quite sure why that's relevant, but I'll ask you, Mr. Stokes, how many times have you cut Mr. Harvey's lawn?
Once.
Okay. All right. Do you remember what month or year you did that?
Let me see here. May 29th of 2022, I believe, Your Honor.
All right.
Mr.
Harvey.
One more question for Mr. Stokes, Your Honor. Can you ask Mr. Stokes, how many times have you came to my residence to pick up packages off my porch?
A few times before the incident happened.
Okay. All right. Do you have any other questions, Mr. Harvey?
No, that would do it, Your Honor.
Okay. So I have a question clarifying that. Mr. Stokes, are you saying like you were picking up packages as a favor for Mr. Harvey?
Yes, this is what him asking me to pick up the package. So we would go and pick up. in the front of the house, hold it until he came back from being on vacation or wherever it was he went. And when he came back, we would give Mr. Harvey the package.
Okay. Okay. All right. Ms. Stokes, do you have any follow-up questions for your witness?
No, I do not.
Okay. All right, Mr. Stokes, thank you for being here. You are excused, sir.
You're welcome.
Mr. Harvey, please mute yourself.
Judge is short.
Mr. Stokes, do you have any other witnesses, ma'am?
I do. I'm trying to get him to log on. He's currently at work. He was logged on all morning. So I'm trying to get him back online.
All right. Well, does it seem like he's going to be doing that shortly?
He's an older gentleman trying to figure out the internet.
Okay, I understand. Okay. All right. Well, I think what we're going to do is if he shows up, we'll go ahead and hear his testimony if we're still doing this.
I know she said please mute, and in my mind, I'm like, wow, she's being so short today. But that is short for her. Like, she gives broad leeway a lot of the time. And I just think it's funny. I think she's getting feedback from his mic or something. It's hilarious. We've got a lot left, guys. Don't worry. There's going to be more, much more testimony of the pettiest variety.
This hearing, okay? But we're going to go ahead and I'm going to swear in. Well, no, I've already sworn you in, Mr. Harvey. So now this is your time to tell me what you want to tell me about the allegations that have been made.
Okay. Can you hear me, Your Honor?
Yes.
Okay. I want to carry this thing back, Your Honor. My wife is a travel nurse. And we travel in and out of state from 3 months to 6 months. And so that's when I asked Mr. Moore about cutting the grass. I don't cut grass. She made a statement about I'm coming over there asking to cut her grass. I don't even cut my own grass, but I got evidence, Your Honor. If you can take a look at my evidence for the police report, which was June. Look at the date. It was June.
We'll look at that in a minute. Let's
Okay.
just get a little bit of what you want to say.
Well, Your Honor, all this is about, like I say, I don't know if they run a car lot out here, Your Honor, or whatnot. Every time we try to back out our driveway, I almost hit their cars. Wife almost hit their cars. I don't even deal with Miss Stokes. I always call her husband. I don't even have her phone number. Every call comes from my phone. It's from my phone number. You'll not see not one number of my wife. They don't have my wife.
Hang on a second. Ms. Stokes, I need you to stay in frame, please, so I know that you're here and able to hear. I just want to make sure, okay? Thank you. Go ahead, Mr. Harvey.
So all this is extended, Your Honor, because we got to do 3-point stands. We almost keep hitting their cars. I call Mo and say, man, we need to talk. We need to be neighborly, man. We don't want to hit your car. And if y'all can just back the cars back up. So they want to come in, oh, your wife needs to learn how to drive. I'll teach her how to drive. I like Mr. Mo, I call him over, Mr. Stokes. Why don't y'all just back the cars up? They won't move the cars. So on July of 2022 was the first initial time I had to call the police. Police came out and asked them to move the car. I also put an exhibit of exactly where she moved the car to, right in front of my driveway, parked the wrong way. So after she moved that car, Your Honor,
Sir. Hold on. Did he just say he's gonna teach her how to drive? Did I mishear that? I may or may not be on the porch. Seriously, fuck.
we come back, there's another car. And I would call Mr. Stokes.
Also, I just need to point this out. Allie B from Tennessee, your last comment showed up on my screen, and the first word plus po was cut off. So all I read was lice have a lot more important things to be doing than dealing with y'all's petty shit. Learn how to be kind and learn how to be an adult. Mind blown, mind blown. Can you fucking I was just like, lice? What is she talking about? Oh, the police. I get it.
Call, and I try to call him again, and then he'll answer the phone. I'll be like, Mr. Stokes, okay, what we're gonna do about all these cars, man? I don't want to keep going through all this issue with y'all. All we want to do is get out of our driveway. Well, let me teach your wife how to drive. They won't move the car. They call the police again. Now, on this last occasion that came up when we had to call the police made them move 2 vehicles off the street because they don't have tags on them. And then what they did, they put 2 more that they took out their driveway back on the street. They got a total of 6 cars parked out here. That's what this issue is about, Your Honor. No one is stalking her. Only been in her house one time to help fix a hot water tank. And at that time, that was me and her husband both in there fixing a hot water tank. Never been in Miss Stokes' house but once fixing a hot water tank. Have not been on her property. Have not followed her to no store. And she trying to say when I open up my garage, I smoke cigarettes. My wife was diagnosed with cancer. I don't smoke in the house. I either smoke cigarettes in the garage or on the front porch. That's why I sit and drink and have a beer on my front porch. Every time I come out my driveway, my garage, Your Honor, my trash can is sitting right beside my garage. So I open up the garage door to come out to throw trash into my trash can. I go back into the house. But we're homeowners. They're renting, Your Honor. She's not going to dictate when I can come out my garage, when I'm shut my garage, come in or out, when I can sit on my front porch. And she also mentioned about our cameras, Your Honor. We've had these cameras up here for the last 5 years. We got a camera over our garage. We got a ring on the front door, and we got a camera in the back of the house. But this case has got nothing to do with stalking. She's upset because I keep calling the police about moving all these vehicles. And when we start looking at my exhibits, you can see every time the police come, she claims she's going to file harassment. All this time I've been waiting on harassment charges. Like I told the police for death, if you think me harassing you because I want to get out my driveway, file your harassment charges. Yeah, on the 29th, I'm on my way to a funeral. On the 29th, going out the door, I get served by a sheriff going to a funeral. The sheriff told me, and I talked to him, I told him what this is all about. I said, it's all about them cars out there, sir. He told me to take my pictures and present them to you. So this is what she talking about, me out there taking her pictures, Your Honor. It's after the sheriff told me. And then I'm coming, my birthday was just Sunday. So I'm trying to come out my garage and go get my vehicle inspected so I can get tags. She's on my side of the street working on a truck. And I thought this TPO, so I'm violating your TPO, Your Honor, just to come out my garage. I'm within 10 yards of her because she's over here on my side of the street.
Mr. Harvey, has Miss Stokes told you in the past that she doesn't want to talk to you?
Never.
She's never told you that?
Never. I don't even talk with Miss Stokes. I deal with her husband.
Has her husband told you that to not talk to her?
Never. And to mention, come to think about that, Your Honor, I can pull it up on my Ring camera. Miss Stokes and Mr. Stokes got a big argument. He's over here and in front of my camera. If I have to pull it up and we come to court, I'll bring it there. He's screaming back across the street to her, bump you, herpy ass. But I said, Mo, man, it's quiet, bro. It's like 11, 12 o'clock at night, man. Don't be cursing across the street. He's talking about his wife got herpes. And like I say, I'd rather do this in court so I can bring that evidence.
So what? Hold on. You guys, I am always, I'm slacking. I was literally texting on the job. We have to go back because this is important. I gotta stop texting on the job. I won't stop texting on the job. Okay, well, you're the boss.
You?
Never.
She's never told you that?
Never. I don't even talk with Miss Stokes. I deal with her husband.
Has her husband told you that to not talk to her?
Never. And to mention, come to think about that, Your Honor, I can pull it up on my Ring camera. Miss Stokes and Mr. Stokes got a big argument. He's over here and in front of my camera. If I have to pull it up and we come to court, I'll bring it there. He's screaming back across the street to her, bump you, herpy ass. But I said, Mo, man, it's quiet, bro. It's like 11, 12 o'clock at night, man. Don't be cursing across the street. He's talking about his wife got herpes. And like I say, I'd rather do this in court so I can bring that evidence. He's in my
This is
yard.
our court hearing. This is our court hearing. And whether the two of them have arguments is not relevant to this case.
Yeah,
okay.
But,
So I don't need to hear about their personal arguments in the middle of the street.
No.
Okay, that's not appropriate. So Mr. Stokes, let me ask you though. What I asked you was if either of them had asked you not to speak to her, and you said that they never have. That's never happened. That's your testimony.
Yes, ma'am.
And is it also your testimony that when she's outside that you don't try to speak to her?
No, ma'am, I don't speak to her. No, I never spoke to her.
All right. And where are these cars parked? Are they parked in front of your home, behind your, on the other side of the street, behind your driveway?
Okay, they got two parked on my side of the street, Your Honor. If
Do
I'm
you have
cutting grass,
pictures you need to show me? Is that what you want to
yes,
do?
all the pictures are in my evidence.
Okay. Okay. Madam Clerk, can you pull up his evidence, please? Thank you, ma'am. All right. What are we looking at here?
Okay, let me pull my thing a little closer here. Okay, right now, Your Honor, the two vehicles you see in the driveway are the two vehicles that the police made a move off the street. The other blue vehicle is parked in the neighbor.
Y'all, these are not the cars I thought we would be seeing here. Is that a Ford, like, Ranger or something? Also, it could be a Mercedes, the black one in the driveway, but it could also be like a, I don't know.
In front of the neighbor home on the side of her. So these pictures you see, I'm actually taking these pictures from my front porch.
All right. Is that's her house across the street?
Yes, ma'am.
All right. Can we go to the next picture, please?
Now, those two pictures, Your Honor, those are two other cars that she has. One is in front of her house. The other car is blocking the neighbor house that's on the other side of her.
What do you mean blocking?
But she's not blocking. She's parked in front of both neighbors on both sides of her, Your Honor. She's got
Okay.
vehicles on. Yes.
All right. Next.
Now, this is a picture, Your Honor. If I want you on this one here, if you can see the cone, but they do every time they move the vehicles up. Before this started, Your Honor, they cars used to be parked right there at the end of their grass. If you see the orange cone, if you bring that vehicle all the way up to the cone, that's where they used to park. So every time we try to back out the driveway on them, we're about to hit their car. So the last time the police came out, which was just the last report, that was what June the 30th or something like that. So since then, they have put a cone there, Your Honor, so they don't impede my driveway.
All right.
Now, this is the picture where I was just telling you earlier. I'm coming out my garage, Your Honor. That's the trash can I'm telling you that sits beside my garage. When I open up my garage, I'm either going to throw trash out or I'm going to my vehicle. This day, I'm on my way out to go get my vehicle inspected. My birthday was just this Sunday. I'll open up the garage. Now, they're on my side of the street, Your Honor.
Happy birthday to you. Your neighbors are screwed. You guys have a fucked neighborhood. And I'm glad I live in Canada. Also, F in the chat for Ray. But actually, we talked about the abdominal thrust maneuver. It is not the Heimlich anymore. It is called the abdominal thrust maneuver, and everybody should learn it so that you can do it on somebody else, but also on yourself if you're alone by using a corner of a table. Anyways, let's keep going.
Matter of fact, that telegram pole, I got the only street light in the whole neighborhood. My property go all the way over to that green box, what you see right there. And as soon as I step out my garage, I'm violating your TPO that you put on me to keep us 10 feet apart. So they always want to come over to my side of the street, keep doing everything they got to do. And I feel stranded in my house. Okay, am I going to get locked up if I get in my car? I got things I got to do. That's him and his wife right there.
All right. Is there another picture?
Now, that red car, Your Honor, they put that car in here, been sitting there for a whole month with no tags on it, with test drive tags for a whole month. Then they swapped that car out, then brung in the truck, Your Honor. It's like it's a revolving doors with all these cars keep coming in. Like I said, as long as I can get out my driveway, Your Honor, I don't have no issues with them.
Okay, next.
Now, this him, he got somebody out here doing service work again, Your Honor. I come out, my whistle bell on my alarm, which we have the camera right over the garage. And it just kept going off. Every time, like, baby, why is our phone keep ringing? So I look out, it's just saying Dita detected motion. So when I go out to see what's going on, this is Mr. Moldham again, out here working on his truck right at the edge of my driveway. So Like a sheriff told me to snap all the pictures that I want you to see. So while I was out there, I snapped another picture.
Okay.
So I love my chat so much because they're explaining to somebody who's asked about F in the chat. And I love the explanations we've got here so far. So when you hear me say F in the chat, that is just, okay. Well, it started in this here room because of it's so, I get in trouble in a lot of chat rooms, okay? I am not appropriate. I say inappropriate things. I steer conversations in bad ways. I promote spam, apparently. Anyways, so, but I love the internet and I spend all my days on YouTube. So I was like in a weather related room and the guy's hat flew off or something like that. And I wrote in the chat, F in the chat for his hat or something like that. And I got like mods. I still laugh so hard. The mods really slapped me down. They were like, do not. I mean, today I got in trouble for something else, but that was a little more overt. That was just me being me. Like, I say F in the chat in my regular life. I'm like, F in the chat for the lasagna that burned, or F in the, like, it's just because of how old I am, I think. But it has now become something on this channel. It's nuts. I was like, first of all, the conversation here is just fine. My F in the chat request for his hat was funny. It was bang on. It's not like I'm in here spamming. I was watching your program. You just talked about how he lost his hat. F in the chat for the hat. Like, I really didn't think I was doing anything wrong. I was in there with my kitchen court cases user name. Like, I'm not in there like as a troll. Like, I was in there just like, this is me. I know it is now. Like, context specific, except F in the chat on the internet is pretty regular, And see, Richard, we don't have to worry about. And then that's the other part I get in trouble for, is being too sexual. But yes, the story is me personified, basically, which is like, yeah. I'm a green stoplight. If you have an idea that you probably shouldn't do, but you come to me and talk about it, I'm gonna be like, yeah, no, you should definitely not do that at all, but like keep going. Okay. It wasn't even Ryan Hall. I was supporting, but I love Ryan Hall, y'all. Prissy, I love it. I know, it bothered. Why F in the chat for the hat gets in trouble, but people are like, what's the forecast in Seattle? And they're like, well, we're dealing with like tornadoes down over in this part of the country. It's crazy. Again, I was engaged. I wasn't like, those people could scroll through the fucking 7-hour forecast and find when somebody actually paid for them to answer that question. Mine was just like right there, I felt very, very slapped back when I read that and was talked to. So regardless, in this room, you are not going to get in trouble for most things. Ali B from Tennessee. Thank you so much. Sorry for being part of the spam that demonetizes you. But you know what? If I don't have the spam that demonetizes me, I wouldn't have the spam that monetized me to begin with. And it really wasn't the court cases that we saw. It was the friends that we made along the way. That's important, Ali B. Thank you so much. Seriously. I love you guys. Like, seriously, earlier today, I joked verbally on screen about how you should be careful when you fucking glory hole that is wooden because you'll get splinters. Like, this is definitely not for children. Thank you, Ali B. Okay, let's keep going.
Next picture, please.
These are the test drives, Your Honor. That car is sitting right on the edge of my property, been sitting there for a whole month until the police gave her 5 days. And I got a police report. I think I sent you the police report. He gave her 5 days to go get a valid tag on his car. They keep bringing all these cars in here with no tag and just parking them all over the place.
Okay. How long was that car parked there?
A whole month with test drive. Not one like
Okay.
dealership. It just say test drive.
Okay. All right. So are you just presenting your police report because you wanted me to know you called the police?
Yes, each and every time I call the police. They also have some more pictures, Your Honor.
Courtney, you've made me laugh so many times today. You just made the fucking best comment of the day so far. Absolutely. Thank you so much. This is real practical advice, ladies and gentlemen, straight to you from Courtney. Always remember, duct to cover the edges on your glory hole. See, I initially thought it said duct tape. My brain read that quickly, laughed real hard. Now, ducting, I'm a little more concerned about, but it reminds me of a story that I learned from a dominatrix that I met once who explained, and here's the thing. Nails are sort of gross. They're not everybody's thing. I like short nails, but like I love having manicured nails. It makes me feel very pretty. But there is this sort of like, you can't play as much with really super long nails, obviously. And I remember meeting this dominatrix and she was explaining to me, and I was like, I love your outfit. I also like your nails. I'm going to ask you a practical question about how you keep your nails like that and how you do your business. And she explained to me that she used cotton balls and gloves. So she would like stuff the ends of her gloves with cotton balls and wear gloves so that it became like there was no issue. I was like, wow, that's such a grand idea for anybody with long nails that they don't want to, like, because the rule is when you go play, you need to go ahead and make sure you've got lovely manicured and trimmed nails. I just thought it was a great workaround and I wanted to share it with you. And Courtney, again, you reminded me with what I thought was a duct tape hack, which I think would work. If you've got a glory hole and you do duct tape, yeah, I bet that would work perfect. Bondage tape would be fine too, but it doesn't stick to things, it sticks to itself.
I don't know if she saw any more. Did you see any more, Madam Clerk?
This is some different exhibits coming up now.
All right.
Now, on this night,
Same
Your
page
Honor,
then, Courtney.
let's go back to June 30 of 2022. This is the first night that all this started. We was good neighbors at one time. You can see the police car out there. So what the police did on this night, they had all the cars. And I made the initial call for them to stop blocking my driveway. And if you go to the next one, when she moved her car, Your Honor, I want to show you where she parked her car at. Now, when the police made her move her car, you see two cars in her driveway. She parked her car on my side of the street, blocking my mailbox. So by the time the police officer got down to the bottom of the hill, she stopped again. She told Miss Stokes, I have two problems with this, Miss Stokes. First of all, you're parked going the wrong way. Now you're blocking his mailbox. So she was upset. She hauled her car across the street and parked it right in front of she's on my side of the street, Your Honor, going the wrong direction. And I don't think that's the attitude of somebody that's being stopped. If I'm stalking you, why would you park your car on my side of the street at nighttime like that? And
What's this picture?
Right, it's the same thing. Because it was dark, I wasn't sure if the first photo went through, Your Honor. But yeah, that picture just showing on the first night all this took place.
Okay. All right. Anything else, Mr. Stokes? Anything else, Mr. Stokes?
The ring's back.
You meant Miss Stokes?
I'm sorry. I didn't mean to say Mr. Stokes. I meant to say Mr. Harvey. I'm sorry.
No, well, one thing I have left to say, Your Honor, because like I say, on the day I got served, which was on the 29th, I'm on my way to a funeral, and I didn't kind of understand this TPO, ma'am. And I call the police so he can give me a clarification of your TPO, whoever put the TPO in place, that wasn't the first time she came over here, Your Honor. She keep crossing the street here, working on that little burgundy car. Then she's come back across the street working on that truck, and I feel like I'm violating your TPO as soon as I come out my garage. So I want to have some clarification on how this TPO
Sure.
is supposed to work.
Okay. Just so you know, and I'm not talking about making my decision right now, but the TPO you were served with, it says that parties are neighbors. Respondent shall not approach or speak to petitioner. However, nothing in this order shall prohibit respondent from entering or exiting his own property or interfere with his use thereof. So yeah, you're allowed to take your trash out and drive in and out, but that's what that order, whatever. I'm just answering your question about that.
Yes,
okay.
ma'am.
All
I
right.
understand.
Now,
Jonathan, is that a rosary? Do you know, as I look at it now, I see that it's a rosary, but I'm going to tell you guys, you've heard the story about my emoji language and the 3 mics. Yeah, there was 3 mics. The one I fucked, the one I wanted to fuck, and the one that called. And we've talked about how after this is another tip for all of you. You can use emojis and nobody knows what that means because it's personal to you. So you can have like a fucking crazy warning emoji ahead of somebody's name if they all happen to be Mikes. And for example, you will not mistake the wrong Mike and forget to text him. Or text him and like literally knock him down a few pegs and be like, I will absolutely never sleep with you. Anyways, that's a wholly different story. But the reason I asked is because, Jonathan, that is the emoji I use for people that tie up other people. So like I realize now because I'm seeing it quite large on the TV that it's probably a rosary, but I used to look at it sort of like ropes. And it's definitely like the emoji name of a few people in my phone. Also, what else was I gonna say? Um, yeah, that one, exactly. Exactly. Jonathan, I was like, wow, Jonathan's like deep in. He knows my little emoji. Because the other day I said my favorite emojis, and that was the one I put. Bondage does equal a rosary for me. Oh, my brain thinks automatically of some really cool bondage necklace. Anyways, we gotta keep going. I am okay. It's real hot here today, and I am like, I'm going on a date. I forgot all about that. I'm going on a date.
did you have anything else you want to say at this time, Mr. Harvey?
No, ma'am.
All right, Ms. Stokes, do you have any questions you want me to ask Mr. Harvey?
Yes.
What is the first one?
Ask Mr. Harvey if when the first time he asked us to move the vehicles, did he state that he would?
It's a late date, Prissy. It will be pretty long. Don't worry. It'll be my date's not for like 2.5 hours, so we good. Oh, the date? Yeah, we'll probably be. I don't know. Actually, we'll see.
Was asking because he was drinking and driving the night before and almost hit the car.
Mr. Harvey, did you ask them to move the car the first time because you were driving while intoxicated?
No, I wasn't, Your Honor. I've asked them numerous occasions to move those vehicles. One get no response. Like I say, Mr. Moore at work. I never communicated anything to her. All communications, all the phone calls she got are to Mr. Moore, her husband. I don't deal with her. I don't deal with nobody wild. Every call I got, I call Mr. Moore, didn't get no answer. So, like I say, they're gonna tell me, teach my wife how to drive. So I called the police. No one was trying to do all this stuff that she's saying. No.
Right.
When
Right,
I called
Miss.
the police, I said,
Okay, I don't think she's talking about, her question wasn't about when you called the police. I think she just said when you asked them. Okay. Next question, Ms. Stokes, and if you can please put your whole face in the frame. Thank you.
Next question.
Actually, I'm more interested in your ring, and I'm trying to order it right now from Temu.
Can you ask Mr. Harvey if he was asked for Miss Miles to come out the home and speak with me? with regards to the parking?
Yes.
Miss, all right, go ahead, Miss Stokes.
And during that time, did I not have a conversation in the presence of him, Miss Miles, and my husband with regards to the parking situation?
Did you was that all that in front of her husband, you, and your
Yes. Yes.
And what was Miss Miles' response at that time?
What did Miss Miles say, Mr. Harvey?
I can't remember what she said, Your Honor, but she's upstairs. Can we direct this question to her? Because I can't recall exactly what was said.
If you don't remember, that's a fine response. Ms.
Right.
Stokes,
Don't remember. I do remember they're still trying to teach her how to drive. I remember that portion.
All right, Ms. Stokes, any other questions?
Can you ask Mr. Harvey whether or not this, maybe 2 weeks ago, when we had a storm in the area and had no power, whether or not he stood outside of his garage staring across at me and my family as we were trying to pick up tree debris?
Mr. Harvey, did you stand outside after the big storm and stare at them?
No. No, Your Honor.
Okay.
I'm trying to remember power outage. No.
Can you ask Mr. Harvey, did he or did he not just have his camera over his garage installed on June 22nd of 2023?
Did you have your camera installed on June 22nd, 2023?
No, replace, Your Honor.
All right.
Replace.
Okay.
Not installed, replaced. One with another company.
Ms. Stokes, anything else?
Is it? Can you ask Mr. Harvey if it is not accurate that this past Sunday, Mr. Harvey pulled out of the driveway, almost hitting my car because he was intoxicated?
Okay. I'm not gonna ask that. It doesn't sound
Thank you, Your Honor.
to do with this situation. All right. Anything else?
Nope, not at this time.
Okay. All right.
Wow, we still have 15 minutes. Well, that depends actually on how. No, I think we do. But regardless, let's get our votes in now. I feel stupid asking this question. I mean, I believe this will be dismissed. If somebody disagrees with me, I want to hear your points. At this point, I have not heard one single thing. And a stalking TPO is the hardest of the 3 types of TPOs to get in the state of Georgia, which is where this is happening, DeKalb County, Georgia. The stalking TPO requires a persistent and pervasive, like, pattern of stalking behavior, regardless, could be between strangers. There is a sort of difficulty when you're dealing with stranger on stranger violence or harassment, because there's most of the TPOs are for family violence or domestic violence. And so the rules are very much skewed towards that. And so if you want to get a TPO against somebody who's not been in a dating relationship with you, then the best way is only going to be getting the stalking TPO. Basically, there's like no other one. Yeah, Crystal, you strolled into a lot. If you scroll up, we went a little crazy. Best chat, and well, it's a traveling chat. I can't claim you all as my own, even though I have a home for you here always. But this is a traveling chat that goes from room to room and is awesome, and I love them very much. We've talked about glory holes. We've done some meme lore. We explained what F in the chat means, both generally and to me specifically. And Ray, oh, you can definitely claim me. Okay, claimed. Love it. Grammy Rita, you've got the grandkids here. Loving it. That's awesome. Thank you, Courtney. You made me laugh today many times, my friend. We have, do we have a Discord? We sort of do. We have Mayor Wrench McNome. I have a corner in that Discord, and then I also have a corner in looking at legal stuff's Discord. I am not responsible enough to have my own Discord. It's the reality. Like, I just am not in charge. I can't be in charge of that. I'm already in charge of this, and it's hard. But I come every day. I come every day. Ray Bay died on a grape. KCC is claiming dead women. Do not. Jonathan, I am planning on traveling internationally. I do not need this kind of talk about me.
Mr. Harvey, I wanted to ask you a couple of things.
Yes, Your Honor.
Ms. Stokes testified that after the TPO you were served with a TPO, you were outside with some friends who were hollering at or trying to speak with Miss Stokes. Do you recall that?
No, Your Honor.
Do you recall anything about that, being outside with friends while she was outside?
I had friends on the front porch on Sunday, Your Honor. Sunday was my birthday. The wife was also out there. I had 3 of my buddy friends came over to wish me happy birthday, and we was.
Did he say boyfriends? I think he said good friends. My brain's processing it later. But at first, I heard boyfriends. We're going to go back and listen. Just imagine him like waking up on his birthday on a Sunday, like, it's my birthday, my boyfriends are coming over. I'm so excited. Oh, look at the neighbors have parked their 6 cars again. There's no spaces for my boyfriends.
Sitting in the back, y'all, but the son sits in the back. So we took it to the front porch, Your Honor. Like I say, I smoke in the garage or either on the front porch. I can't smoke in the house. So it was me, my wife, and 2 of my friends sitting on the front porch. I didn't even look her way. I ain't seen Miss Stokes, and I swear on the oath, no one yelled at Miss Stokes. So to that answer, no.
She put the happy birthday for him, Kimberly. Let's go. Oh my God, it's a deeper thing than we thought. She's the stalker. Oh my gosh. And yes, Grammy Rita. This dress I've worn on a cruise ship before. Actually, a lot of my dresses I have, but I remember this dress.
All right. What about well, never mind about that. Okay. Do you have any witnesses you wish to present, Mr. Harvey?
Yes, let me get my wife.
All right.
I should be upstairs. Give me something. Matt. Hold on, Your Honor.
Go ahead and get her.
Matt.
Judge is so over it. He yelled so loud.
Come on down, baby.
You can post it in the Discord, Beverly, if you've got pink clouds.
You can sit on this side. I'll put you in front of the camera. I'll scoot over here.
All right. Good afternoon, ma'am. Can you please raise your right hand for me? Do you swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
Okay, thank you, ma'am. Put your hand down. What is your full name, please?
Magdalene Miles.
Magdalene Miles. All right, Miss Miles. And Mr. Harvey, you can go ahead and get in the frame with her. That'll be fine.
Okay.
So, Miss Miles, I'm going to ask you some questions about this situation. I only want you to testify about what your personal knowledge is. Okay? Things you've witnessed yourself. And Mr. Harvey, I don't want you, I know you're sitting right next to your wife, but I don't want you to indicate answers to her. Okay? No. I want you to stay in frame, but I don't want you to tell her what to say. Okay?
Oh, I'm looking directly. I'm not taking my eyes off you, Honor.
No, it's fine. I know, but sometimes, you know, you're just like, no, remember when? I don't want to
No,
name that. Okay.
I'm in contact with you.
All right, Miss Miles. So we're here on about a stalking petition against Mr. Harvey. What is your personal knowledge about this situation? What have you witnessed yourself, the goings on between, if any, Miss Stokes and Mr. Harvey?
Yes, it was today, people in court. And if you were doing your job, you'd know that I'm just joking. I'm just being a bitch. Hi, people in court. Bluebell, what's the matter, sweetheart? People want to love you. They want to see you.
Well, Yana, the only thing, I'm just gonna give you a little history. I met Miss Stokes way back when, many years ago, and my husband Rick and her husband and herself, they were very good friends. They would be outside talking. He would be in their garage. They would be over here on our porch talking. They were friends. I was never involved in their conversations, but they were very good friends. And then now I'm finding out that there was a stalking charge, placed against him. The biggest thing, the problem was we were having problems getting in and out of the driveway. And Rick asked them to move their car. And the biggest thing was they were trying to tell me how to drive. They need to teach me how to get in and out of the driveway. And my thing was, if you just move your car, that's all I need. I don't need conversation about me. Teach me how to drive. Just move your car and then we're good. So I'm not sure where the stalking came into about him stalking them. So far as him in and out or whatever, the way it is, he sits on the front porch, he sits in the garage, that's just the way it is. But no, I don't have any reason or any reason to believe he's stalking them, and he's not.
Okay, this is weird. Also, Samson, welcome. But Donna's had a wrench since day one, and I'm not trying to start any wrench battles. That's not what's happening here. That's in a different month. I think I'm gonna do that in October, actually, when we're gonna have Modness month, where I test some abilities. But Donna is a very good friend of mine, Orlando Chiquita, been here for a long time, and knows how crazy I am, and actually just sent me this in the mail. Oh, I do. But the dog gets really upset when I play with this without letting her touch it, so I haven't played with it today since the dog's been around.
All right. Well, let me go ahead and ask some more questions. I've got a consent order I need to take here in a moment. But Miss Miles, have you heard your husband try to speak to Miss Stokes while she's outside on her property or in the street?
No, no, ma'am.
Okay. Miss Stokes, do you have any questions for Miss Miles?
Miss Miles.
And you're going to ask me, Miss
yes.
Miles, this work is she's going to ask me a question, and I'm going to make sure it's okay, and then I'm going to ask you. Okay, go ahead, Miss.
Can you ask Miss Miles whether or not her and I had a conversation last year with regards to parking and the conversation that was had?
Do you remember a conversation with Ms. Stokes last year regarding parking?
Yes. We had a conversation.
Go ahead.
We had a conversation. It was her husband, Rick, and myself. We were out in our driveway, and we talked about the parking. And so she asked me, why haven't I said anything to her? I said to her, I don't like confrontation. I don't like all this back and forth. But Rick asked them to move their car. And she said, and both of us agreed, that they would move their car and stay on their side of the street, and we would stay on our side and not block their driveway, and they were not going to block our driveway. But as time went on, the cars kind of inched back in the driveway, where we parked, when we got out, it still was blocking, and Rick approached them, but we did agree that they were not gonna block our driveway and we were not gonna block their driveway. We would be friendly neighbors. If we spoke, we spoke. If we didn't, we didn't, and let it go as that.
All right, Ms. Stokes.
Hold on. Something's happening, but isn't that just the implicit agreement of all driveways, which is don't block them? I just thought, I didn't know that that had to be an agreement. That was just like an implicit sort of understanding about driveways. Am I wrong on that? That's crazy. Also, hi Hayden. Hope you're doing well. I started up way early today. This is such drama. Can you imagine living in this neighborhood? Oh my gosh. Be worse than having a lady who lives in your neighborhood who watches court and chases all day and screams in her backyard while dancing with the dog.
Can you ask Miss Miles whether or not they've impeded my driveway since then and I had an issue?
Do you remember impeding Miss Stokes' driveway when she had an issue?
No.
Okay. Miss Stokes, any others?
Does she recall the police coming out on the 29th of June of this year?
Do you remember
Or
when
any
they
day?
came on the 29th of June?
No.
Does Miss Miles recall telling Mr. Harvey to leave it alone on July 4th and to go in the house?
Miss Miles, do you remember telling Mr. Harvey to leave it alone on July 4th and go in the home?
No. I don't even know. No.
Anything else, Miss Stokes?
Does Miss Miles recall any conversation with Mr. Harvey about leaving the neighbors alone?
Miss Stokes, have you ever told Mr. Harvey to leave the Stokes family alone?
I had a conversation with Rick, Miss Stokes, and her husband at that night saying, let it go. You park on your side, we park on our side. You don't block our driveway, we don't block your driveway, and let it go.
That was last year when you all were
Yes,
talking?
ma'am.
Okay.
Yes, ma'am.
Has there been any other time when you've told Mr. Harvey to leave them alone?
No.
Ms. Stokes, anything else?
Was she aware when this all began of Rick calling the police back in 2022?
Whoa, Dana, flex tape would probably work on a glory hole. What a great suggestion, Dana. Thank you so much. This is why we come together, because we, as a hive mind, we can really solve some of the world's problems. Deborah Baker's here. Welcome. Also, people in court, I'm the oldest of 4 girls, so you can try and bully me, but it's okay. Rolls off my back.
What do you mean, calling them again? Is that what you mean?
For the first time.
And to be clear, she's not bullying, we're friends, it's fine. Plus her stuff is weak.
Does she remember calling the police? Is that your question?
No. Is she aware of Mr. Harvey calling the police back in 2022 for the very first time?
Do you remember when he first called the police? No. Okay.
No, ma'am.
Ms. Stokes, anything else?
No.
Okay.
Actually, I do. I have one more question.
Okay.
Is Ms. Miles legally still married to Mr. Harvey at this time?
I'm sorry. What? Okay. Why is that relevant?
Yeah, that's what I want.
Why is that, Ms. Stokes? Why is that relevant?
Because he keeps referring to her as his wife,
Okay.
and she's not.
All right.
She's the
We're not
owner
gonna.
of the
It's
property.
fine. We're just gonna move on from that. It's not relevant. Okay, Ms. Stokes. Anything else?
Nope, that's all.
Okay, y'all. I'm gonna put everyone in the well, Miss Miles, you can go on about your day or, wherever in the house.
Okay.
And I'm going to put the parties back in the waiting room because I have another consent order I need to take, and then we'll be finishing up your case. Okay.
I don't know if I got the full end. I think I did. Actually, I don't know.
Are you ready for 14?
Let me just pull it up. Miss Johnson, thank you so much for all your hard work. You're amazing.
Oh, thank you so much. My pleasure. Thank you for yours.
Oh, well. The balance of never mind. Okay, let me move this so I can see it and talk to everybody at the same time. Okay, we can bring in the parties.
Okay, let me pull them out the breakout room.
Okay.
Okay.
All right, thank you so much, both of you.
Okay, so guys, here's the thing. I'm looking and I realize I don't know that we did get the rest of this, but I'll tell you something. If this TPO gets put in place, I will personally go to Georgia to request a copy if somebody proves that it did, because I don't think it could get put into place. But we're not done for court, so don't worry. We are not done at all. We have another throwback judge that, again, I don't know why we sort of subject ourselves to these things. Well, I'm doing it. I'm the one subjecting you guys to it. But give me 1 second here. So, let me just pull this up here. So what we have is, you're gonna love, hate it. You're gonna love, hate it. Actually, little palate cleanser. Maths is hard. I'll just say that.
Ready? Good afternoon, ladies and gentlemen. Welcome to the show cause docket for the afternoon of July 20, 2023. These proceedings are being live streamed on YouTube in order to comply with the law that requires this to be a public hearing. No recording of the proceedings are permitted. In a moment, I'll call on the first individual and in your case or cases. And what we're trying to do, I think most or all of you have a similar problem in that you were perhaps on a payment plan but have not been able to keep up with it because of financial problems that have come along, or you were going to set up a payment plan but have not been able to do so yet. So what we'll try to do in your case or cases is get you on a plan that is workable, something that you can stay with and keep up with, so that you would not have to appear again for another one of these show cause hearings. Okay, the first individual is Charlicia Blankenship. Okay, Ms. Blankenship, it looks like you were on or we're going to start a $30 a month payment plan. Is that correct?
Yes, sir.
All right, can we get you on that plan, or could you pay more, or is that the best you could do?
I can pay the 50.
Pay 50? Okay.
Yeah.
How often? Starting when and how often?
I get paid twice a month, so.
Okay. You want to pay that 50 twice a month or 50 once a month?
I can do the once a month because I can do the full. I can just give y'all. I'm gonna just give y'all 100. So I'll just put it together. So you can do it twice a month. It's fine. Yes.
Well, whatever would work best for you. Would you like to do 50 a month or 100 a month?
I can do the 50.
Okay. Starting when?
Next week. I get paid next Tuesday.
Okay. That would be July the 25th. Let's do that. We'll put you on a 50 a month plan starting July 25th.
Okay.
All right. Thank you, ma'am.
Thank you.
Wasn't that confusing?
Mary Elizabeth Brown. Okay, Ms. Brown. Okay. All right, looks like you were on a plan back earlier this year at $25 a month. Could we get you back on that same plan? That's about as low as we could go.
Yes, sir. I'd appreciate that. I have seizures. I'm actually at work right now. I just started a new job. And that's the problem I have is my seizures. I'm not going to go too in full details. I have really bad seizures, and it tends me to lose my job a lot. Like I've lost like 7 jobs since this has all even started. I'm working at Super One now, and it's a really easy job. I'm just cashiering, so shouldn't be any problems. I can start paying. I can start back paying. If you could give me until the 23rd of next month. I haven't been able to even pay any bills at all. Like to the point I'm about to lose everything because of these seizures. So,
all right.
I can start back paying on the 23rd. I'm looking at the calendar now. I'm at work. I'm looking at my boss's calendar for my pay date.
Okay, we'll do you on $25 a month starting August 23rd.
Yes, sir. And I will make sure I get that to y'all.
All right, very good. Thank you, ma'am.
Okay, thank you very much.
Tatum Cates. Okay, Cates, looked like you were going to set up a payment plan, but have not been able to do so yet. So tell me what kind of a plan you could set up and when you could start it.
Yes, sir.
Yes, ma'am. I can hear you okay.
Okay.
Okay, what kind of a plan could you set up and when could we start it?
Can I do $50 a month?
50 a month?
On the 20th? Yes, sir.
Okay.
And can I start the 20th of next month?
Okay, we'll do that. $50 a month starting August 20.
Yes, sir.
Very good. Thank you, ma'am.
Thank you.
Do you think somebody got their kid to call into court? We have to go back to reopen the lemonade stand, Jonathan. Oh my god.
Okay.
We're going to set up a payment plan, but have not been able to do so yet. So tell me what kind of a plan you could set up and when you could start it.
Yes, sir.
Yes, ma'am. I can hear you okay.
Okay.
Okay, what kind of a plan could you set up and when could we start it?
Can I do $50 a month?
50 a month?
On the 20th? Yes, sir.
Okay.
And can I start the 20th of next month?
Okay, we'll do that. $50 a month starting August 20.
Yes, sir.
Very good. Thank you, ma'am.
Thank you.
Okay, Burnaby Coronado Jr.
Yes, sir.
Coronado, looks like you were on a payment plan of $50 a month. Can we get you back on that same plan?
Yes, sir. Can I make a payment on the 18th of August?
Okay,
I just started a job.
let's do that. Let's go with 50 a month starting August 18th.
Yes, sir.
Oh, very good.
And I had a question as well.
You what?
I had a question
Okay.
about the tickets. I was wondering how I could get back my license quicker. What's the way I could get it back faster so I could drive the company trucks?
Very good. All right, well, we'll get you on this plan here. All right, thank you, Mr. Coronado. Okay. Cunha Caprice Dunbar. Okay, Ms. Dunbar.
Yes, sir.
Okay, we need to get you on a payment plan. Looks like you were going to set one up, but haven't been able to do so yet. So tell me what kind of a plan you could set up and when you could start it.
I want to do the $50 a month, and I can start August 15th.
Starting August when?
15th.
15th?
Yes,
All
sir.
right. We'll go with $50 a month starting August 15th. All right. Thank you, ma'am.
You're welcome.
Okay. Frederica Freeman. Okay, Miss Freeman. Looks like you got quite a few cases. You were on a payment plan of 25 a month.
Yes, sir.
That's about as low as we can go.
I'd like to point out yet again that the cost of administrating these hearings is absolutely probably more than $25 a month. You have to think about that, right? Like the cost of putting all this together, having all the staff, like sometimes the debt is a detriment to the state or the county as opposed to actually being better off collected in a way.
Can we get you on that plan again?
Yes, sir. I just had lost my job and I wasn't working, but I started back a new job at Walmart, and I get paid like August the 3rd, so I can start paying again.
All right. You want to start your payment plan on August 3rd or not?
Yes, sir, if possible.
We can do that. We can put you on a plan of 25 a month, and we'll start you back up on August 3rd.
Yes, sir.
Thank you, ma'am.
All right, thank you, sir.
Taylor Harris.
Yes, sir.
Okay, Ms. Harris, looks like you were on a plan of 50 a month. Can we get you back on that same plan?
Yes, sir.
Starting when?
On August the 1st.
August 3rd?
1st.
Okay. We'll start you then at 50 a month.
Thank you.
August 1st, but was that August 1st?
Yes, sir.
All right. Okay, thank you, Ms. Harris.
Thank you.
Jose Jamaica. Okay, Mr. Jamaica, looks like
here. Yes, sir.
Like you were on
a plan.
Comes undone. You were on a
You were
plan.
on a plan.
Yep.
Yep.
I just noticed the flashing lights as well as the ceiling fan. Judge Kim would have a connection.
Like you were on a
plane.
Let's try that now. Maybe that's okay. You were on a plan of $50 a month. Can we get you back on that same plan?
Yes, sir.
And starting when?
I could pay it next Friday.
All right. Next Friday would be July 28th. Okay.
Yes, sir. Yes, sir.
Very good. Okay. Let's see here. Next, we have Mr. Brian McGall. Mr. McGall, looks like you're on a plan. Or maybe we need to get you on a payment plan. That doesn't look like we have one set up yet. How much could you pay and when could you start, Mr. McCall? Hello, can you hear me? You might need to press *6 on your phone.
Hello.
Yeah. Okay, we can see you, but we can't hear you.
I'm not sure if they can figure it out between the two of them.
Can you press *6 on your on your phone? Looks like he's trying to do it, but we're not getting anywhere with it.
Can somebody send that 6-year-old that was on earlier over to help this guy with his phone?
You don't have a star. You should be getting a prompt to unmute.
F in the chat for Brian. I'm cooking some food. This is crazy. But there's a really good case after this, and I don't want to skip around. Oh, apparently I did give up. Previous Kitch was like, no, we're not doing this. You need to turn it off. But don't worry because I went back because of what I started hearing from this guy. Do we have a creepy neighbor follow-up? No, I'm the creepy neighbor. Oh no, there were creepy neighbors, but I'm also a creepy neighbor. What is going on? This is crazy. But wait till you hear what he starts talking about. It's this guy. I thought it was somebody else. It's this guy. Just wait till you hear what his charges are, first of all.
There we go. Now,
There
can you
we
hear me?
go. I can hear you now, Mr. McGaw.
Thank you.
Okay. We need to get you on a payment plan. Tell me how much you could pay and when you could start.
I'm paid $50 and I can start tomorrow.
$50 a month starting tomorrow, which would be July 21.
How much do I owe?
I'll look here and see. Yep, how much you do owe. $1,294.
What about the time I sat out? I sat out the tickets. I stayed in jail for a good 6 days.
Yeah, you only owe 42 on this one. The other are set for pre-trial on, well, no, they've already been set, July the 11th. Yeah, they were set for pre-trial on July the 11th. You had 2 animal at large cases.
I was going to fight that one. That's just.
Yeah, you're set for jury trial on those 2 cases, Mr. McGaw, the 2 animal at large cases.
The animal at large, they charged me and they charged my ex-girlfriend.
Uh-huh.
And there was just one animal that we had, but she's already on a payment plan.
Mm-hmm.
I explained this to some folks, and I'm saying we get charged. We both get charged for the same animal.
Mm-hmm. Well, I don't know what the facts are in that case, Mr. McGaw, and I guess that's what the jury trial would be to determine is what are the facts for the one animal, how it worked in. But What I'm saying is that you are set for pre-trial Or set for jury trial. Yeah, you're set for jury trial. We don't know yet when it will be. We're trying to catch up, but you will be notified of the date and time when your two cases are set for jury trial. Okay.
All right. The other one I just saw $45 on.
42.
42. Okay.
Yes, sir. Can you
Pay
pay that?
Yes, sir. I'm gonna pay that tomorrow if that's okay.
That's fine. You just pay that $42 tomorrow.
Yes, sir.
All right, sir. Thank you.
Thank you.
It's so confusing. We're not done yet either, guys. I recorded this.
Everybody, good to see y'all.
Oh, God. You don't even have to see your face to know who it is, do you? I'm just going to tell you guys right away. Part of my process when I record court sometimes is that I have to do it in 2x speed because I listen to court in 2x most of the time anyways, but I got to get as much in as I can. But recently I thought maybe it's a little unfair. Maybe the sound quality after the fact is what's making some of these people sound a little bit fucking drunk, and that lady's volume's hot. It's not all, but I can change my volume a little bit, Afix. But here's the thing. You don't know Allie B, but so the first video I did of this lady, the thumbnail I made was like alcoholic beverages because we all thought she was really drunk. I recorded this at 1x speed today because I thought, I don't think it's fair that I am going to pin her into this, whatever. So you'll see when it cuts off. So this is just a snippet of a hearing, but you're going to see why in a minute. This judge is a piece of work.
Again.
Good afternoon, Judge.
Calling cause number D1GN18001981. This is a motion to enter, which I call the billboard case, right? Okay. All right.
Your Honor.
Now, do y'all need a record?
I do not, Your Honor. I'm Chris Rothfelder. I'm here on behalf of the plaintiff, John Gannon, Inc. And I don't think we.
Thank you for your appearance, Ms. Bonamy. Please make an appearance.
Yes, Susan Bonin, representing TxDOT and its officials, Mark Williams and Kyle Madsen, and we are fine without a record.
Okay. Thank you, Ms. Albrecht. We'll let you know when we need you to jump in. So those are appearances for the docket notes. And we have a motion to enter. Who would like to begin?
Your Honor, it's my motion, so I'm happy to begin.
Yes, go ahead. I did see that. I couldn't remember if this is one of the ones where we had competing motions to enter. So thank you for that. I appreciate it. You may proceed, Mr. Rothfelder.
Thank you, Your Honor.
Thank you.
And I'm glad that you've already got a name for this case. It lets me know that I can kind of skip past some of the facts and history and get right to it. So of course, what's at issue in this case is TxDOT's, we've been calling it relocation guidance policy in this case, the guidance or the rule. It was adopted in 2016, and the issue, the provision of the guidance that is the primary issue in this case is the requirement that TxDOT now imposes on billboard owners that own billboards that are impacted by highway widening projects, that in order to receive a TxDOT relocation permit, the billboard owner has to agree upon a value for the condemned sign prior to a special commissioner's hearing. Otherwise, the billboard owner forfeits the right to that TxDOT relocation permit. And of course, the relocation permit entitles a billboard owner to relocate its billboard or in effect build a new billboard utilizing relaxed spacing criteria. So whereas TxDOT generally requires that you be within 800 feet of two businesses for a new billboard, for a relocated billboard using one of these relocation permits, you only have to be within 800 feet of one business. Most billboards have to be 1,500 feet from another billboard.
MB, are you joking me right now? You know this judge? I am being totally upfront. We roasted her last time. Was that the case? It was the case with two lesbians. The lesbian, was it the lesbian custody case? I think it was the lesbian custody case. It's an old video of mine, and it is, and we thought she was drunk. I'm going to be honest with you. I didn't even push it because I thought it was the video recording, and which is why I did this one in real time. Yeah. So, but if you really know MV, that's interesting. And of course, always an open invitation to most people that I feature on the show, not the criminals, but the judges, to come on and alleged criminals, come on and talk. Odd but very nice. That I get. She's the one where she interrupted to ask about the tacos during the closing arguments, the shrimp tacos. Mike covered that case that day too. I did too, but
a relocated billboard only has to be 500 feet from another billboard. So it's a valuable right to a sign owner in connection with a condemnation case. And so on May 30, you heard the defendants and plaintiffs' motions for summary judgment, as well as Ms. Bonin's motion to dismiss for lack of jurisdiction. You denied the defendants' motions. You granted the plaintiff's motion, and in doing so, you held as a matter of law that the relocation guidance policy was an invalid and unenforceable rule under the Administrative Procedures Act. I should back up for a moment and say that there's no dispute that TxDOT didn't adhere to the rulemaking procedures of the Administrative Procedures Act. It didn't put notice in the Texas Register, ask for comments, or any of those other requirements under the APA, and instead issued the guidance in 2016 in a department memorandum. So at the end of the hearing back in May, you asked Ms. Bonin and I to work together to agree on a form of order, and we were able to agree on the majority of the contents of that order. The one issue on which we couldn't agree was whether or not the guidance should remain in effect while on remand to the Department of Transportation. TxDOT has maintained that it needs 18 months to properly implement the guidance under the APA rulemaking procedure. This case has been on file since 2018, and it's the plaintiff's position that TxDOT shouldn't be given another 18 months to enforce an invalid rule. The dispute centers on this court's interpretation and application of Texas Government Code 2000.
Okay, so it cut off after that, and that case is a little boring, but the next one was actually quite interesting. It's about
Could do
figure
a breakout
skating,
room if that was
which is
possible,
unusual.
just so we could talk to you.
Oh,
We
why
got
don't
to
you just
pull
go ahead
through a
and make your
bunch.
To Ms. Worley for her review.
Thank you.
on the
So they go into a breakout room. Sorry, I'm just remembering. They go into, look at that lady. She's like looking off. She has a really high monitor. Okay. Where is she looking? Oh, she's elected. She's an elected judge.
Disputes and we versus HEB.
Sure. Ms. Albrecht, did you?
Judge, before you start that one, we have two more cases. There's that Sanchez versus HEB case at the bottom. It has a 20-minute announcement.
Okay. True that.
Oh my God,
It
she
was,
did not just say
it was,
that. This judge, holy shit. She just said true that.
Judge, before you start that one, we have two more cases. There's that Sanchez versus HEB case at the bottom. It has a 20-minute announcement.
okay. True that. It was so much like the last one that I think that I was like, okay, let's do that one then. Sorry. So if y'all will hang tight, we'll get back to you.
Thank you.
On the ice skating case. All right? All right. So you can turn off your cameras and mute your mics, but don't log out. Thank you.
This is not a joke. I believe
Are
she's
y'all
right.
ready on the HEB case?
We are, Your Honor.
Yes, Your Honor.
Okay. Do y'all need a record?
Yes, we do, Your Honor.
All right. Calling cause number D1GN22005899 Sanchez versus HEB LP. This is a plaintiff's motion to compel and defendant's motion to quash. Please make your appearances for the record.
Good afternoon, Your Honor. Albert Garcia for the plaintiff, Estrella Sanchez.
All right, thank you.
Good afternoon, Your Honor. Norma Worley on behalf of HEB.
All right. All right, what makes sense?
Judge, I think I can short circuit things. I have a motion to compel. Ms. Worley did give me some supplementation yesterday and produced several other documents. So I think I can pass on that motion while I review all that stuff. And so all we have left is her motion to quash.
Oh, okay, thank you so much. I'm just making a note that you are passing without prejudice
Correct, Your Honor.
with time so that you can review the documents to make sure that everything that you requested is there.
Right. And I also have a representation. One of the other things was a recorded statement that her client took of mine. She did promise that would be forthcoming. So with that representation, I think I can pass it.
Okay. Without prejudice. To refile it, to re-noticing. Okay?
Thank you.
All right. So the motion to quash. Ms. Worley, you may proceed.
Thank you, Your Honor. Plaintiff is seeking the deposition of an employee of HEB by the name of Michael Lucio. Michael Lucio works in the risk department of HEB, basically is like the adjuster, HEB being self-insured. This is a premises liability case. Mr. Lucio is the individual who is from risk assigned to investigate the case, investigate the matter. My objection to having Mr. Lucio deposed was because any information that he has, anything that he knows, anything that he's garnered, one is protected under the work product and attorney-client privileges, but also because anything that he has learned about the case, he's not a witness, he's not a fact witness, he is basically, it's all hearsay. He's not
a witness to any of the events. He is simply a gatherer of information. And the information that he gathered after he was under the impression that there was a likelihood that this would go to litigation. Now, in his response, Mr. Garcia seems to acknowledge that his testimony with regards to his investigation would be protected by the privileges that I previously mentioned. What he states in his response to my motion to quash is that he wants to depose Mr. Lucio strictly on the allegation that he's making of spoliation. The spoliation allegation,
hold on. It took me a while for this because it'd be so long in between times that I would hear it. Spoliation.
Spoliation. Thank you, Your Honor.
There you go. You may proceed.
Okay, so the spoliation claim is because of a video that was obtained by Mr. Lucio shortly after he found out about the incident. He found that there was video of the incident at the store. He took that video and he preserved it. Between that time and when suit was filed and the video was requested, Mr. Lucio at one point had to turn in his computer to his employer for updates. When he received his computer back with the updates, he did not know that the updates had affected some of the files that he had preserved in his computer. When the suit was filed and he needed the video that he had preserved to present to me as counsel so that I could present it to opposing counsel, he realized that there was, he couldn't find it. So he went to his IT department and told them about the situation, and they tried to find it, to relocate it, and they couldn't. So in other words, that and a couple of other files were lost. But Your Honor, this is not spoliation. Mr. Garcia has indicated that in his response that he lists spoliation and he lists the elements for spoliation, but he does not in any way assert how the facts in this case fit into spoliation. Mr. Lucio did preserve the evidence. The fact that it was lost or destroyed was beyond his control. It was not intentional and it was not negligent. It was a destruction of evidence that was beyond his control when he was complying.
Thank you so much, Allie B. from Tennessee. Welcome to kindergarten class with Judge. Spoliation. Spell it out now, kids. Seriously, it is a bit cringe. Guys, I've just put a poll down in the chat. If you're just a lurker listener, but you want to get your vote in on what you think of this judge, please go ahead and put your votes in now. Yeah, this is a crazy judge. But I mean, good for me. The fucking food on the stove. Okay, keep going.
With what his employer requested he do with regards to his computer. There is no spoliation here, Your Honor. It is simply an unfortunate event that we were unable to present the video that was captured and was preserved initially. We did not hide that fact from opposing counsel. We never kept it a secret that we had retrieved the video at one point and had saved it. So I don't understand how he is going to establish that we have spoliation in this case.
All right, response.
Thank you, Your Honor. As a procedural matter, the court should deny the motion to quash. As the court knows, anytime a party opposes discovery and lodges some objections, the party has an obligation to present evidence in support of those objections, either at a hearing with testimony hearing or an affidavit filed at least 7 days before the hearing. The court has no evidence to support the objections, and it should be denied on that basis. Now, getting to the merits, while Mr. Lucio may be a claims adjuster of some sort, I don't know. I haven't asked him a single question yet. Ms. Worley is correct. I do intend to file a motion for an instruction based on spoliation. However, as the court knows, if I don't submit any evidence in support of that, it'll get denied in 10 seconds. So I'm trying to establish some evidence about this video that HEB admits it had in its possession after it received notice of a claim from my client, the notice which contained a request to preserve evidence, or it may be subject to a spoliation instruction. According to the interrogatory responses, Mr. Lucio, the person who I want to depose, viewed the video, had possession of the video, and at some point it was lost. Now, everything Ms. Worley just told you can't be very privileged because she just told everybody what happened, but I need to get it in the form of evidence. I can't present to the court what Ms. Worley stated because that she doesn't have personal knowledge. I need to hear it from the records custodian, the person who had the video, who had it in his possession. And I need it in the form of evidence because the Texas Supreme Court has stated that if you want a spoliation instruction, you need to prove to the court, the trial court, with evidence what happened and when. And that's what I'm seeking. I'm not seeking any kind of privileged materials from Mr. Lucio. As the court knows, a video of the incident itself that is filmed contemporaneously with the incident is not subject to an investigative privilege. Now, after the accident happens and someone conducts an investigation and they take video, let's say surveillance, for example, that would be subject to investigative privilege. But there is no case law that I have seen, that I'm aware of, or that Ms. Worley cited that says a video that is filmed contemporaneously of the accident that gives rise to the lawsuit is in any way subject to any kind of privilege. So for those reasons, I'd like to depose Mr. Lucio to find out a little bit more about what happened to that video, whether copies were made, who else it was circulated to, et cetera, so that I can submit a proper spoliation motion when the time is right. So I'd ask the court to deny the motion to quash and allow me to take that deposition. By the way, she did list him as a person with knowledge of relevant facts, so it's unusual that she would list him as such and then deny that he has any facts. So
Now, would like you said, work product and what else?
Attorney-client.
Okay. I'm tending to agree with Mr. Garcia on the law, and I was looking for his prayer. What date?
His prayer? Is she saying that? Also, I just tried to say F in the chat and it won't let me type in the chat. I hope things are still working.
Mr. Garcia on the law, and I was looking for his prayer. What date was the motion to, oh, your response to the motion to quiet? Here it is. Here it is. I just wanted to look at the prayer. I looked at this. I remember the pictures, of course.
Is prayer? I believe she's saying prayer. This is so weird.
Do you remember your prayer? What you're specifically asking me to do, just to depose Mr. Lucio?
Yes, Your Honor, to deny the motion to quash. I have
Yes,
that.
and
Your Honor, if you've got his response up, if you look at paragraph 3 of his response, he indicates Lucio's deposition is relevant to the issue of spoliation. If the court is inclined to overrule the motion to quash and to allow him to depose Mr. Lucio, I would request that, just as he's limited it in his response, that the court limit the deposition to the issue of spoliation only.
well, what say you about that? Because I mean, I was going to give Ms. Worley a chance to see how we might limit this, but of course, any assertion of privilege or work product can be made at the time of the deposition, and then ruled on later. But what would your parameters be, Mr. Garcia? Just about the spoliation instruction that you may need to give at some point?
And I'm okay with that. I suspect that with a given question, there may be a disagreement as to whether it's within the parameters of spoliation, but I'm okay with that in general, and that is all I need from Mr. Lucio. I don't intend to ask the man for anything within the realm of attorney-client privilege and things like that.
Well, what about witness statements and things? I think that that's fair game if he's the repository.
Well, it is
the right word. Repository, depository.
custodian of records, I guess. That's right. And it would be within the realm, and I'll tell the court why. I think I mentioned in my response that the timing of when he took a recorded statement from my client and learned from her various issues, such as were there any warnings and how far were they, which would be shown on the video. So she tells him, hey, there wasn't anything there. The only warning was, far away. Well, that would be reflected in the video. And that is one of the issues that Ms. Worley is raising in her summary judgment, for example, that is set, a few weeks from now, and I have to respond. So I will ask about the recorded statement because it's relevant to the timing of when this video got lost.
Yes. So I don't think I'm going to put the limitations on it, Ms. Worley. I think that you can make contemporaneous objections and assertions of privilege at the time of the deposition. We're off the record.
Okay.
Mr. Garcia, do you have a proposed order?
I don't believe I filed one, Your Honor. What I'd like to do is prepare one circulated to Ms. Worley for her review as to form and then submit it to the court if I may.
Yes, and if you email it directly to Ms. Latham, it will be much faster.
I will do that.
Do you need that email address?
I think my paralegal has it.
Yeah, and it's copied on, you got this link from Ms. Poe, but she's copied.
I did. I got it.
Okay.
I'll circulate it this afternoon, Your Honor.
Great. Thank you so much.
Thank you. May we be.
Thank you, Your Honor.
Yes, y'all have a lovely rest of your evening and a great weekend.
Thank you. Everybody be safe.
You too.
Okay. Thank you.
True that, Judge. True that. Now we're getting to the figure skating case. I said I wasn't gonna be going. Who was worried about me not going long enough today? No, we got more. We got more.
Now, did y'all say you needed a record or no?
Yes, please.
Okay. All right, calling cause number D1GN21006104, Cabell versus Lee et al. Now, why don't y'all just go ahead and make your appearances?
I'm Pete Rutter for plaintiff Lee Cabell. I'm at DC Law.
My name is Ashley Morgan, and I'm here on behalf of the defendant, Chaparral Ice.
All right. What about the individuals? Do you represent them too?
No, ma'am. That would be Mr. White, who's here on the Zoom.
Oh, and Mr. White.
Mike White of She Ware on behalf of the defendants Yi Li and Jia Ying Li. Good afternoon, Your Honor.
Mm-hmm. Yeah. Good afternoon. Thank you. Are you going to be arguing or just observing?
It's not my motion, so I will not be arguing today.
Right. That's what but anyway, so I just didn't want to I just wanted to make sure I didn't pass you up if there was something that you needed to, that you felt like you needed to say, because this isn't only an MSJ. So why don't we
MSJ means motion for summary judgment.
start with that? It seems like to me that might be the easiest one to start with. All right, you may proceed, Mr. Rudder. No, Ms. Morgan.
Thank you, Your Honor. We're here presenting a no evidence motion for summary judgment. This is a partial no evidence motion. We're only asking for dismissal of plaintiff's gross negligence claims at this time. By way of brief background to acclimate the court with the case, this is, as the court mentioned, an ice skating related case. The injuries underlying the lawsuit occurred on June 11th of 2021. This case has been pending since October 12th of 2021. So as I mentioned, I represent Chaparral Ice. That's the ice skating rink where the incident underlying the lawsuit took place. Mr. Cabell, the plaintiff, it was 65 years old at the time. He was a figure skating coach. He had been within the ice skating industry for upwards of 61 years. He was there coaching one of the defendants, Ji Yang Li, who is a 7-year-old skating student. The accident occurred when Ji Yang Li was practicing some backward crossovers. At the time, Mr. Cabell was coaching another student, and Ji Yang Li accidentally ran into or skated backwards into Mr. Cabell, and he was knocked to the ice. And we're asking that the court dismiss the plaintiff's gross negligence claims. As the court knows, there are two elements to a gross negligence claim. We're attacking both elements, Your Honor, and arguing that there's no evidence of either the objective element or the subjective element. So objectively, from the standpoint of the actor, that would be Chaparral Ice, at the time of the occurrence, the complaint of acts or omissions must involve an extreme degree of risk, and that's taking into consideration the probability and magnitude of potential harm to others. And as far as extreme degree of risk is concerned, that's not just a remote possibility that there be an injury or an accident. Instead, it's a higher threshold than that. And the actor must have actual awareness of the risk involved, but proceed with conscious indifference to the rights or safety of others. And so in order to show that that actor proceeds with knowledge, that harm has to be a highly probable consequence, not just a remote possibility. And so we're arguing, Your Honor, that there's no evidence of either of those elements. And we do have some objections to the summary judgment evidence that was attached to the plaintiff's response. The first objection relates to Exhibit C to the plaintiff's response. That is an expert report by Lisa Fedek, who's providing expert opinions about the obligations and duties of an ice skating rink. That expert report was not verified. It does not state that all of the opinions are within her personal knowledge and true and correct, or have any of the accoutrements or components of an affidavit. And as such, it's not proper summary judgment evidence, Your Honor. We've cited various cases and also secondary materials in the reply to the response that we filed yesterday that support that an unverified expert report is not competent summary judgment evidence. And without being verified, it cannot raise a fact issue. So that's the first objection, Your Honor. The second objection relates to a paragraph. It's paragraph 1.01 of the plaintiff's response. That's just beneath where the plaintiff lists out the exhibits that they're using as summary judgment evidence. That paragraph refers generally to all items, basically all pleadings, all discovery, and any affidavits that might be on file at the time of the response. The reason that we object to that, Your Honor, is that Rule 166A clearly states that any summary judgment evidence that someone intends to utilize to oppose a motion must be specifically referred to or attached in the motion. So the general catch-all is very unclear as to what summary judgment evidence the plaintiff is referring to. So that would be our objection. Getting into the more of the substance of plaintiff's response, we don't believe that it raises more than a scintilla of fact as to either of the elements of gross negligence, Your Honor. There are some references to questions that I had posed to the plaintiff in his deposition. Plaintiffs attached the entire nearly 300-page deposition transcript to their response, but they're only citing to questions that I asked, driving at our affirmative defensive assumption of risk, but unsworn statements, or rather questions by counsel, are not summary judgment evidence.
Oh my God, I remember now. Deborah, thank you for saying that. You guys, you're right. The judge was herself put as a vexatious litigant. And Deborah says, I only thought about Grindr for men. Well, yeah, but in my town, as long as they say no homo first, then it's not gay. So it's everybody.
And so looking at the merits of plaintiff's response, it really doesn't raise more than a scintilla of fact as to either element. So as the Supreme Court of Texas has outlined, there's less than a scintilla when it's just a surmise or suspicion. And that's what we have here. One of plaintiff's arguments about this motion is that it should be denied because there hasn't been adequate time for discovery. So we don't dispute that that's a requirement that's set forth in 166A subpart I for no evidence motions. However, we believe there has been more than adequate time for discovery on the issue of gross negligence in this case. As I stated earlier, this case has been pending since October of 2021. So it's been pending or had been pending for about 20 months by the time that we filed this motion. Up until last week, plaintiff had not sent any discovery requests to any of the defendants. Up until last week, plaintiff had also not made any requests, to my knowledge, for any of the defendants' depositions. As part of their...
What level discovery was pleaded?
This is level 3, Your Honor.
Okay, you have a proposed, scheduling order already in place?
Yes, we do. We do, Your Honor. And the discovery period is scheduled to close on September 13th. We're set for trial on November 13th. So we've got less than 2 months left in the discovery period. And part of plaintiff's argument as to why there hasn't been adequate time for discovery is that the discovery period has not yet closed. However, if the court looks at the case law that we cited both in our motion and our response, Texas courts, and specifically the Third Court of Appeals, have not determined that that the discovery period has to be over by the time you can actually file a motion for no evidence summary judgment. So, for example, in the Actor versus Schlitterbahn case, that's a Third Court of Appeals.
That's a fucking water park, Schlitterbahn. Wow. Yeah. And also Debbie Deb D. That's all I will call you from now on. Debbie Deb D. All 3 though. Only all 3. Debbie Deb D.
Appeals case from 2022. The Austin Court of Appeals found that there was adequate time for discovery where the case had been pending for 7 months. So we're well beyond that. This case has been pending long enough that I could have almost had 2 children during this time. And
what an odd marker of time, lady. And plus, are you counting like if you were banging right after giving birth, or are you talking about a proper amount of time in between? Those are real differences. That's not a very fair measure of time. No. Your whole argument was great sort of up until now, and now you've just thrown out like, "Oh, I could have had 2 babies." Well, did you have 1 baby? Like, where did this come from? I could have had 57 babies, but
still we hadn't gotten any discovery requests. So the other issue that plaintiff points to in their response as to why they contend there hasn't been adequate time for discovery is that the plaintiff had only recently been deposed in June. But there again, Your Honor, we ask that we not be faulted for that, because looking at, the diligence and performing discovery, Mr. White had begun asking for plaintiff's deposition in December of 2022. I've provided in box, as I believe it's our Exhibit 3, a series of emails about plaintiff's deposition. So we'd asked for his deposition in December, in March, in April, and then finally we just unilaterally noticed it because we hadn't gotten a response. At that point, we learned that Mr. Cabell was not available on the date that we'd selected. And so I think to everyone's credit on this Zoom, we all conferred and we did get a date set by agreement. And then we also were able to confer about the format. So we'd initially noticed it to be on Zoom, and then we learned that it was the preference to have it in person. So Mr. Cabell flew in from Wisconsin to have an in-person deposition, and that was done in June. And so we don't believe that Mr. Cabell's deposition being taken in June is an indicator of whether or not there's been adequate time for discovery. There has been adequate time, and we've made multiple requests to take that deposition. So we believe there has been adequate time, and that's supported by the case law, Your Honor, and that the defense should be permitted to proceed on this motion. As the court's aware, the timetables get tight when you get close to trial, and it's helpful to everyone if we can kind of narrow the issues before we get any closer and before we all have to start submitting our pretrial documents. And that's what we're asking for, Your Honor, is that the court grant summary judgment on.
Reminder, this is about a 7-year-old be figure skating into somebody. Like, let's just bring it back to where we're at here. I don't know how long this goes on for. We won't be watching all of it. We'll watch another 15 minutes or so. Then People in Court is starting, and I have things to do
On the gross negligence claims today. Thank you.
Okay. Response.
Judge, good afternoon. My name is Pete Rudder. I am here representing Lee Cabell, the plaintiff in this case. It's good to meet you, and I have a short response, and I want to let the court know that I think when you come to the courthouse and ask the judge for dispositive motion granting like they are today, they need to come with clean hands. And at 1:33 p.m. today, I received 15 documents, the only documents that I've ever received from defendant Texas Made Sports Development since they answered mandatory disclosures some time ago. My client has been undergoing treatment for traumatic brain injury in reference to a fall that he suffered at the Chaparral Ice Skating Rink. We just received at 1:33 today a copy of a video that I think in defendant's response to my response or reply to my response, whatever you call it, she said that my client had viewed the video and had access to the video. Well, he didn't have access to the video. The video was never provided to us. We didn't even have the video of the fall, the significant fall that caused the traumatic brain injury. Never had it. So they just replied to the disclosures that they did several months ago with this video and 14 other documents. Like I said earlier, I think that there is time in the discovery control plan, the agreed scheduling order, to conduct whatever discovery is necessary for trial. However, this is a complex case. My client is still undergoing treatment for his traumatic brain injury. I doubt that we're going to.
Let me ask you this.
Yes.
How, and please do not take this as insensitive to TBI, because I certainly am. But how would that relate to the gross negligence claim, and whether you have produced enough evidence that the child and the parent supervising the child were grossly negligent, subjectively and objectively?
Well, for example, we have had a plethora of problems in this case. The defendant Chaparral, the one that Ashley Morgan represents, filed for bankruptcy. So we had this stay in this proceedings for several months, and we didn't have the court sign the scheduling order, the level 3 scheduling order, until late November of last year. My client was in the thick of going through not only DTIs, medical care, treatment for the traumatic brain injury, all the way through June. I even think that he's still conducting treatment. I'm not sure what his deposition testimony was, but he just was deposed on June 14th. I didn't want him deposed until he was done with all of that treatment. I expect both sides, in mandatory disclosures, we have provided every piece of information on a consistent and monthly basis. We have not received anything. And as the court knows, the disclosures require you to provide any and all documents, whether it be digital form or not, that relate to this subject matter. They produced an insurance policy and an incident report, and that's it. Lo and behold, I put in my response that we have not received not another document from defendant Chaparral. I get 15 documents at 1:33 p.m. today. I would say that's not clean hands. If you've had those documents, I could have provided those to my expert. And keep in mind, Judge, the expert deadline was July 13th. We just now got our report from our liability expert, who would have loved to have seen the video, who would have loved to have seen all these documents so that she could produce the necessary. Did I lose her?
No, I'm still here.
That she
I'm
could
listening.
produce.
I'm doing a line or a shot.
That she could produce an expert report that would be more tailored to this specific incident, but she was not given the opportunity to do that. So what I had to do was I had to provide the expert report on July 13th. We have not deposed her, nor has anyone asked to depose her. I was planning on having her come testify live at trial, but now they say I can't use my expert report to show that there's a scintilla of evidence as to gross negligence. Her report is clear and replete with evidence of gross negligence, and I think she's going to testify as to that issue. So the fact that that they've objected to me using that expert report, I find that a little bit hard to take when I get 15 documents at 1:33 p.m. today, less than 30 minutes before the hearing on the motion for summary judgment, so they can at least attempt to argue that they have clean hands, Judge. Objectively, I think there's clear and present danger of extreme risk. My client suffered a traumatic brain injury, and if I can, I'll play the video for you that I just saw for the first time less than 15 minutes ago.
Mr. Rudder.
Yes, ma'am.
The motion is denied. All right, what's next?
What? Did she just do that like that? Did she just do that like that? That's crazy. Well, Irving, you better send me a message then, because I am going to Orlando. Seriously, that's insane. She's so chatty. She asked where the shrimp tacos are, and then this?
Less than 15 minutes ago.
Mr. Rudder.
Yes, ma'am.
The motion is denied. All right, what's next?
Oh,
I believe there's a motion. There's a motion to quash or a motion for protective order, Your Honor.
I know, but who thinks who should go next? I don't know why this got scheduled with so many. Now, the special exceptions, I can't remember what the special exceptions were about, but I did write down that it was filed on the 31st of March. So I must have read it.
And Judge, just for the court's information, we have repled. We've amended our petition and added some additional causes of action against Chaparral and also against the other named defendant. So I'm not sure if that needs to be heard. If it does, then I'm fine to hear that as well. But that's Ms. Morgan's motion.
Well, if you've repleted since then and there's not a new special exceptions, then that's not right.
If I may, Your Honor, before we move on, did I understand the court is denying the motion for summary judgment?
Yes.
Would it be possible in the order to specify that that's without prejudice to refiling?
What say you, Mr. Rutter? I did think of that, but I don't know. It sounds like you're going to have a bunch of discovery fights because it sounds like there was a video that was available before today.
And I'm sorry, Your Honor, would it be possible for me to respond on that issue? Because I think it makes a difference.
I just don't, and it just seems kind of, I understand it's gross negligence, and that's a really high standard, and we're talking about a 7-year-old backing into a skating coach of, his entire career. I was inclined to grant the summary judgment, but because, it just seems like when I read it that there wasn't, enough there. But then he says, wait, we just got a bunch of discovery. I haven't even had a chance to look at it. So to me, that says you're in, any MSJ is denied, but go ahead.
So if I may, Your Honor, and may I share screen with you?
Sure.
So I'm going to show you what is attached as a response to plaintiffs, or attached as an exhibit to plaintiff's motion, attached to plaintiff's response to our motion. In Mr. Cabell's deposition, he spoke at length about having seen the video, and I honestly didn't know until I read plaintiff's response to our motion that they hadn't received a copy of the video. I legitimately thought they had it because in his deposition, Mr. Cabell, as you can see, refers to the video. Mr. White asks him, "You're referring to the security video from Chaparral?" "Yes." "And you've seen that video?" "I have." And he describes at length what happened based on the video that he'd seen, because he didn't remember from personal knowledge. So everything that Mr. Cabell testified to about what happened is from his review of the video. And at no point during that deposition did Mr. Rutter ever say, "I'm sorry, Ms. Morgan, we haven't seen that. Can you give it to me? We don't have it." I legitimately thought they had it. And within a reasonable time after I learned that they didn't have the video, I produced it. I know it's not a great excuse, but I'm not the first attorney on Chaparral Ice's behalf on this case. And I knew that Mr. White had the video. Mr. Cabell had testified about seeing the video. So I legitimately thought that Mr. Rutter had it. And in the month that took place between this hearing and when Mr. Cabell was deposed, this never came up. It only came up in the response itself. And there really have been no discovery deficiency letters or anything like that to my office. And I think it's important to note that out of those 15 documents that were provided today, none of those would raise a fact issue about gross negligence. The majority of those documents I provided are
that's your opinion.
Yeah.
Right.
Well, they're waivers. They're documents showing what the waiver looks like on the website, and also the posted signs at the skating rink saying you skate at your own risk. Be careful, keep an eye out for other skaters, things like that. So, I mean, even if the court denied or overruled my objections to the expert report coming in, which I mean, the court could do. I still don't think that that report raises an issue of fact as to gross negligence. And that video doesn't either. And I don't think that defense should be faulted for the video not having been produced earlier when the plaintiff testified at length about it, and no one has ever brought it to my attention that they didn't have the video until last week when we got that response. And so I went back through everything in my files, got access to the prior counsel's email, trying to see, was this produced? Because I thought that it had been, because everyone has talked about the video and it's never been brought to my attention that it hadn't been seen. And so, if the court is inclined to find there hasn't been adequate time for discovery, I would ask that we be able to reset this motion for a later time after Mr. Rutter can supplement. As far as like expert deadlines go, he can supplement his expert's report. This wasn't gamesmanship or an effort to make it so that his experts couldn't see certain documents. And as I said, the majority of the documents we provided related to our affirmative defenses, not, and the signs that were posted and what it looks like when someone who signs up for the application to register for skating signs a waiver, because there's a dispute apparently about whether or not Mr. Cabell signed a waiver.
I'm going to have to go off the record for just a second.
Judge, you're gonna run out quick. I don't know what your limit is, but you got to be careful doing whatever you're doing. What on earth is happening? Oh, Keeper! Hi, Keeper. How are you? I hope you're doing good. Oh my gosh. We are having a great night. Elvis. True, you're bad. For anybody new here, or if you're just arriving, guys, please go ahead, clock in for your shift. Make sure that you've gone ahead and liked the video. Also, I'm Kitchen Court Cases. Oh, I was like, where's my pen? It's right here. And we watch Court in My Kitchen. We're really not sure what's going on with this judge. Keeper, I'm glad to see that you are here. I hope you're doing well and healing up. What is the judge doing? You don't even need to answer your doorbell these days. Like, what could be? It's dab time over here. Yeah, Courtney, good reminder. Black cherry punch and Jack Herrera. Oh yeah, I could fast forward. Yeah, I can.
Let me make my
How
note.
long is she?
All right.
Okay, here we go. Also, I know people in court starting soon. We will be finishing once this is over. It's not, I hope it's not, it can't be the full length because
Sorry, I had to answer a call from a medical provider. Let's just say that. All right. My apologies, and I'm not making a finding of unclean hands. I know that's how he opened, but I think that's kind of beside the point. But I think that perhaps, Mr. Rutter, that more time for discovery might be in order before it's foreclosed forever.
Absolutely, Judge.
Okay. So, how long? Well, I mean, it's just up to you then, whether you, when you refile and all that. So your denial will be without prejudice.
Thank you, Your Honor.
Okay. All right. So that's settled. All right. Let me make my notes. I'm lost again. Okay.
We've got the special exceptions and then a motion to quash.
Seriously.
Okay, we were on that. We were on the special exceptions, and you said you repleted.
Yeah.
And I needed to know because I didn't know that at the time, and I read this. Plaintiff has repleted. Did you file a new special exceptions attacking the amended pleading?
We haven't filed new special exceptions, Your Honor, but the amended pleading didn't fix the issue that's raised with the existing filed special exceptions. So in plaintiff's pleadings, he still raises the issue or allegation that Chaparral Ice failed to comply with certain risk management guidelines that were set forth by the Ice Skating Institute of America in August of 1996. Our issue, Your Honor, is that I have no idea what risk management guidelines plaintiff is alleging were violated. And so we're asking the court to order plaintiff to amend his pleadings and specify which of those 1996 risk management guidelines were violated.
Oh man, did I think we would be hearing about Ice Skating Association of America 1996 risk management guidelines tonight? No, I did not. But am I here for it? Yes, I am. And Prissy, you are here for it. You so needed this tonight. A member for 2 months. Thank you so much. We're here for you. We'll see this. This is all actually happening, Irving. This is real. I know. I used to pay people to do these court cases. It was expensive. Also, Allie B in Tennessee. I saw your super chat there. Oh my god, oh my god, oh my god. Seriously, a medical call? How true is that? But seriously, what was I gonna say? Nana's left the door open and the thing on, but that's okay. We'll finish, yeah, we'll just get to the end of this case. This judge she's been declared a vexatious litigant on her own, so she can't file her own lawsuits, but she's able to be a judge, which seems a little bit weird. Oh, Irving, you're bad. And I live on Vancouver Island. I'm not in Vancouver.
Response?
Your Honor, it's in the Health and Safety Code, the Texas statutory legislation that talks about how you can sue a skating rink. It's laid out verbatim in that statute. So that's what we've alleged. We've alleged that they violated those statutory obligations that they owe to the public as well as my client. And I think that's all we're required to do is put them on notice of that claim. If they're saying that they want us to provide them with a copy of that guideline that they're supposed to have had ever since 1997 when it was implemented, be more than happy to provide that to them.
Okay.
Madeline Connor, Madeline Connor.
That's only part. Oh, sorry.
Go ahead.
That's only part of the issue, Your Honor. I understand that the Texas Health and Safety Code does set out that that's one of the ways someone can sue an ice skating rink is if they violated those guidelines. But I don't know which of the guidelines plaintiff is saying that we have violated. And the reason why this is ripe and we're asking for this to be decided now and to have the plaintiff be ordered to amend now is that the discovery period, as we mentioned, ends on September 13th. The latest that I can serve a discovery request about this allegation would be August 14th. So we're asking that plaintiff have to amend his pleadings by August 4th to give us some time to determine if discovery needs to be conducted on that issue. So we're asking that they specify which of the guidelines were violated.
I might be able to help this issue.
Well, he could write a letter today, right?
Rudder giving her another.
Honestly, I don't think that there's.
He can file a supplement to his pleading.
I don't think that there's any way we could be ready for trial in November, is my bottom line. We've got probably 15 to 20 experts that have either put their hands on my client and need to be deposed. There's no way that I'm going to get coordination with these two to say, okay, we've got to take these expert depositions before September 13th. It's not going to happen. So I'm just telling the court that we might need to do a new scheduling order to get the time necessary to conduct all of this, if the court's okay with that.
Well, I know, but you're going to have to put that on the central docket. Because, I mean, I said that early on. Sounds like you're going to need more discovery time. So, okay. So would it be difficult or
Man might not be around.
let me see what I'm trying to say. Would it be difficult for you to quickly supplement your petition?
No, I think I can, and I'll provide her with those guidelines if that helps, and I'll try to be as more specific as I can as far as that violation or those violations that we're alleging, to put
Because
them on notice.
what I might be envisioning is a giant packet of
What?
As far as that violation or those violations that we're alleging, to put
because
them on notice.
what I might be envisioning is a giant packet of regulations from this agency or whatever, and I think that would not put her and her clients on notice.
Okay.
All right. So let's hold that in abeyance, or I can deny that also without prejudice. Is there more though to that special exceptions?
So we are only asking that they amend their pleadings, Your Honor, and that you're spot on. I mean, they do get the opportunity to amend. We're not asking that just be stricken. That would be the procedure would be to have them amend, and then if they don't specify, we'd come back and ask for it to be stricken. But that's all I'm asking for, is for specification.
Right, but are those the only two issues now?
On the special exceptions, yes.
Yes.
And then we have the motion to quash.
Right, but we're still on that. So you're asking that that Mr. Rutter identify which sections of that regulation that was violated, and what else?
Just that there be a deadline to do that. We've asked that it be August 4th.
Good night, Evelyn, and good night, Keith.
I can do that.
Okay. And if you need more time, a couple of days, wouldn't, because you might have to have somebody read that thing.
Right.
Okay. August 4th deadline to replead specific sections of, I don't remember what it's called, policy, regulation.
Good night, Courtney. We'll see you in the morning tomorrow. We are almost done here, guys. The judge, look at the judge's face. Holy shit. John, I need this. Can you timestamp me this one too, Jonathan? Because I just want to get her face. I love it.
Yes, Your Honor. And we did, if it helps, you can copy paste from the Word version of the proposed order.
Okay. All right. I'm just making my notes for the docket. Okay.
Risk management guidelines. Mm-hmm.
All right. Risk management guidelines. The fewer things we have to open to write our notes, the better.
Oh, yeah.
Understood.
Good luck with the doc, Courtney. Let me know how it goes. I'm sure it'll be fine. I know it'll be fine, but let us know. Or, you know what I mean. You know what I mean.
All right. You said somebody said they had a motion to quash.
Yeah,
I have found defendant's motion to quash. Is that correct?
It's the plaintiff's motion, Your Honor.
Oh,
on our
but my
disorder
P looked like a D. I didn't extend those two little. I like those little old fashioned designation. Oh, you can't see here. Like plaintiff and defendant when you're in law school, the little fancy.
I like the delta and the
Yeah.
paragraph. Yes.
Yeah.
We have not had a chance, I don't think, to talk about possibly doing a Rule 11 agreement. I typically do this as a matter of course and enter into a Rule 11 agreement with opposing counsel that we get the records first. We get to redact whatever is privileged or unrelated to the incident. We do a privilege log. We submit all the rest of the records to them. We submit the privilege log, and they get to decide if they feel like something's not privileged or related in some way or some fashion. And then they get to talk to us about getting those documents, or we bring it back up to you. And I think I've proposed that Rule 11 agreement to both opposing counsels, but I'm not sure that they have bought into that or said that they want to do that. I'm not sure. And if they haven't, then we can just do the motion to quash and go forward.
Response?
That had been discussed, Your Honor. I'm not just personally not a fan of doing that. Couple reasons. One is that I've seen in other cases where that's significantly delayed the discovery process, because then we have a records vendor who's in the middle who's saying, can I give this to you? What's the order? Is it, oh, they didn't object, but can I give it to you? And it's a mess. And the other problem is that then we end up back in court several times. So I don't think that's necessary for these records. They're all from treating providers that the plaintiff has seen. I don't want to jump too much into the meat of it, but suffice it to say, we have conferred and we would not like to do that Rule 11 agreement, Your Honor.
Okay, then you may proceed.
Judge, let me pull my motion up on the screen so I can at least refer to it. We filed this motion for protective order, motion to quash as defendant. I think as defendant Chaparral, it might be both defendants have sought discovery from not only treating providers that my client has seen, but also retained experts. And I think there was one retained expert in there, Medimental, that they have sought DWQ documents from, and we have designated them as a retained expert. Also, their requests go back to 2016. This incident occurred in 2021 or 2020, and for some unknown reason, they want records from all these different providers that his deposition testimony indicated that he's not ever seen before this particular incident. So it's a fishing expedition. It's a way that defendants and their counsels and their representatives go after any and all documents, whether they're related or not. And all I'm asking the court is that I want it more specified as to it being related to this particular incident. And if they get records that indicate in those records that my client has ever seen them for a related incident before, then they can go request those records back to that date, not just, hey, we just want all the records from 2016 forward. That doesn't seem fair to a person that's never been involved in litigation, who had a unfortunate severe incident at a particular defendant's skating rink, that they should just open themselves up to any and all records of their medical history. I really don't think that's fair. My client is a figure skating coach. He left Czechoslovakia when communism became a huge problem for him. He traveled, he got to the United States, and he's a citizen of the United States now. And I think the fact that somebody is trying to take advantage of him in this lawsuit, trying to get all these records to develop what.
Did I expect to hear communism today in my videos? No, I didn't. No, I didn't.
Whatever kind of defense they want to develop, I think is unfair. It's highly unfair. It's a violation of his personal right to privacy. I think he has a constitutional right to privacy. And I think that he should be able to, or we should be able to limit in some fashion their ability to get records that they need, and also come back to the court if they need to get additional records. Now, I told the court that this was a complex case, and it is a complex case. My client's been seen by 15 or 20 providers that they're seeking these records from. And, I think the DWQ request is a generally vague, overly broad request for records. I am fine with doing a Rule 11 agreement. And I think in our Rule 11 agreements, we give 10 days for the record company to provide us the records, and we have 10 days to review those records. And then we have to file our privilege log. So it only increases the matter of 10 days. So coming back to the court, I think, is not a problem, because we typically don't redact much from the records. And if we do redact it, we have a legitimate reason, whether it be a privilege or whether it be an unrelated relevance issue. That's why we redact. And I think the last couple of times I've redacted, I may have redacted a total of 10 to 15 pages from my client's records. So I don't think that it causes extra burden or extra time. And if in fact we're not going to trial in November, I think we have plenty of time to do the necessary discovery.
Response.
Thank you, Your Honor. We believe that these are appropriately and narrowly tailored discovery requests. Each of the medical providers for which we are seeking billing, radiology, and medical records are providers that the plaintiff has seen related to the accident underlying this lawsuit. And one of them is also his primary care provider. That would be the Austin Regional Clinic at Wilson Park, where he'd seen Dr. Coughlin. So these are highly related to the issues in this lawsuit. I should note from a procedural standpoint that the plaintiff bears the burden on this motion to quash and for protective order, that they have to show that the privilege applies and that there would be an injury by permitting the discovery to proceed. Something that I think is noted is that there is notable is that there is an exception to the physician-patient privilege in Texas Rule of Evidence 509. That's in subpart E4. If any party relies on the patient's physical, mental, or emotional condition as part of the party's claim or defense, and the communication or record is relevant to that condition. I think that exception applies here because we're seeking records that relate to the body parts and the medical issues that Mr. Cabell is claiming to have suffered in this litigation. With respect to Mr. Rutter's claim that one of these experts is a designated retained expert, that's simply not true. And I would point everyone to an email that Mr. Rutter sent to Defense Counsel on July 6th saying that it appears we filed a motion to quash a DWQ request to Dr. Chrysanthic Parker, that's Medimental, as apparently my office inadvertently designated Dr. Parker as a retained expert. She is a treating physician and will be de-designated as a retained expert. We are not seeking any communications that would be privileged under Rule 195. We're simply seeking records related to the treatment that Mr. Cabell had received as a result of this lawsuit. And then with respect to the medical and radiology, we are asking to go back 5 years. 5 years is a pretty limited time frame. Mr. Cabell, prior to this incident, had diabetes with polyneuropathy. Polyneuropathy is a nerve disorder that can have symptoms that mirror the symptoms of a traumatic brain injury. We are looking to get some discovery about the medical conditions and body parts that Mr. Cabell is alleging are injured in this lawsuit from providers that he'd seen after the lawsuit. So at one point, I believe Mr. Rutter said, well, they can do discovery, and if it looks like he's seen these providers, they can go back. If he hasn't seen these providers in that 5-year window prior to the accident, there won't be any records, so there's no violation of privilege. And it really just, I think this is a narrowly tailored discovery request. There's no harm to Mr. Cabell's privacy interests, and he has made those body parts and medical conditions an issue in this lawsuit, and so defendants are entitled to discovery on those issues. One issue that was raised in plaintiff's motion to quash deals with these billing records. So the billing records we're requesting, again, are just for treating providers, only from the date of the incident forward. We're asking to get information about the write-offs and adjustments made to those medical bills. The Texas Supreme Court, in a 2021 opinion, in Ray K&L Auto Crushers, decided that those write-offs and adjustments that are made as a result of Medicare, Medicaid, or insurance contracts are highly relevant to the issue of whether or not a claimant's medical expenses were reasonable. So that's a common law limitation on what someone is able to get. As I believe, probably all of us in here who have seen a doctor know, the amount that's on the sticker is not always the amount that you pay or that the medical provider looks to get paid. Sometimes they write off tens of thousands of dollars because of those contracts or because of Medicare or Medicaid limitations. And so the Texas Supreme Court in Haygood versus Escobedo and in Ray K&L Auto Crushers decided that it would be a windfall to the claimant if the defendant was not able to argue about those write-offs that should be applied, because it's not reasonable to claim that those are medical expenses incurred as a result of, their injuries or treatment for the injuries. So what we're asking for, Your Honor, falls in line with that recent Texas Supreme Court case law. It's limited in scope. Like I said, 5-year limitation for the medical radiology. The time limit for billing is date of incident forward, all highly relevant to the issues in this lawsuit. So we'd ask the court to deny the motion to quash and for protective order.
All right, last word, Mr. Rudder.
I think if I'm not mistaken, we have to prove our medical bills by paid versus incurred. And we provide affidavits that have that very language in there, the paid versus incurred language, because we're required to do so. The fact that she says that she needs to get those paid versus incurred bills from our providers just omits the fact that we provide that to her. We provided every provider's affidavit with bills attached to that affidavit that we've provided, that we have to provide to the court to prove these bills up and to get a jury to award medical bills. Past medical bills have to be in paid versus incurred form. So we have done that. We've provided those affidavits and we will continue to supplement the affidavit. So to say that they need that is omitting the fact that they already have it. As far as the 5-year request for records, I think it's overbroad because, as I indicated to the court, this incident occurred in 2020, and they're wanting to go back to 2016. So that's almost 8 years ago. We need a more narrowly tailored time period to request these records. And if they find records in there that say, well, back in 2001 or 2011 or 2016, he came in for X, then they can go get those records as well and ask the court for that relief. They just can't go get records to fish. That's not allowed under the rules.
What time frame would you put on it?
Judge, if the incident occurred in 2020, I think a couple of years of prior PC records, the other records that they're looking for, the providers that provided him treatment for TBI related injuries have never seen him before. So I don't care what time period they put on there, but I think a couple of years gives them a good cause for looking at what his prior medical condition was like. And if they find anything that draws a red flag for their discovery purposes, they can call me up and say, look, if you'll look at this record, we're entitled to get those medical records. And I don't disagree with that. I'm an easy guy to work with. And if they don't think so, then maybe we just need to come before the court and have that addressed by yourself.
Ms. Morgan?
Hi, Bailey.
I think 5 years is reasonable, Your Honor.
I don't.
Okay.
I'm not sure just 2 is either, though, for PC.
And as far
as you already have most of it.
So the issue, Your Honor, there are a couple problems or the reasons why we need to conduct.
If you're looking for an easy woman, the Troyalty Podcast. I worded that wrong. I'm not easy. I might be a whore, but I'm not an easy whore. I hope you're well with your beef that's going on. Serious beef. Also, Billy, welcome. You fell asleep, but it's not that late. You're in a bit of a time warp because I was early tonight. The judge is fading fast. There is but 7 minutes left on this tape. I don't know if she's going to rule, if she's going to stop off for another couple lines, if she's mixed up her white claws, if she has some sort of pet under her desk. And I'm not talking about an animal.
This discovery as opposed to just waiting for it from the plaintiff. One is that, while I'm not faulting, anyone on Mr. Rudder's team or anything, but it's best if we can have the ability to get records in a format that is admissible in court and not have to rely on production and have someone go through it first. He's essentially asking to have an in-camera review, but by a party that has an interest in the litigation. And so we're asking to be able to obtain these records through depositions on written questions in a format that has a business records affidavit that's admissible. To get directly to the court's the question, though, I think 3 or 4 years we would ask for. If the court's inclined to say 5 is too far back, we'd ask for it, 4. 3 is probably the compromise between the two numbers if the court thinks 2 is not quite far enough, but 5 is too far.
Mr. Rudder.
I think our affidavits are in absolute perfect form for admissibility in all courts in the state of Texas. Now, if I'm mistaken in that, then Ashley's right, but I don't think she is. I think 3 years is probably too much, but I'll be fine with 3 years.
All right, 3 years.
And if I understood correctly from Mr. Rudder's argument, he's only asking for a 3-year limitation for Austin Regional Clinic, Wilson Park, the primary care provider, and the rest he's claiming that Mr. Cabell never saw. So there's no harm, no foul in the existing form, if I'm not mistaken. If that is, oh, I'm sorry, did you say yes?
No, I think 3 years should be applied to all and any and all requests that are being provided. If they don't have any records beyond the incident date, no harm, no foul. If they've got records beyond 3 years and they only give 3 years and they find records that indicate that it was treated for X, Y, and Z that might relate to this particular incident, the claims of injuries, then they can come back and ask me or ask you for that relief.
Or whatever this word is, I wrote down poly something, symptoms similar to
polyneuropathy.
We can't do it at the same time. You wanted a record. Tell me again.
Polyneuropathy.
Okay.
And if I may, Your Honor, some of these providers, I mean, the types of records they would have are part and parcel or just highly relevant to the issues and the claims that the plaintiff is making for his injuries. So, for example, the Center for Neuro Studies, you don't go there unless you have neurological issues like a traumatic brain injury. And so if Mr. Cabell had seen them within the 5-year period where we're requesting records or had medical records or radiology with them, it's going to be related to brain problems that are highly relevant to our defense of causation and damages in this lawsuit. And I think Mr.
What about all that case law that says you take the plaintiff as you find him? And if it's in there, it's in there. You see it, then you go back and ask for farther back. But there is a privacy concern.
I understand, Your Honor, but there is that exception in the rule, in Rule 509, for when a plaintiff or a party puts their medical conditions into issue. And I don't disagree with you, Your Honor. There is a jury instruction in the pattern jury charge about the eggshell plaintiff, and that I understand that's what the court's getting at. But there is also a requirement that someone prove that their injuries were proximately caused by the accident. And so that is a fight that may happen, but the defense is entitled to discovery on that issue. It is relevant to the plaintiff's claims in this lawsuit. And if he had gone to get treatment for a brain injury, there's a causation issue and something that the defense should be able to get and to argue about as part of their defenses.
Well,
2 minutes left.
I'm going to
Deborah.
limit it to, I'm going to grant that in part and deny it in part because I'm limiting to 3 years. What else? Is there anything else on the squash?
I think that's it, Judge.
Okay.
And if I'm understanding Your Honor's ruling, that's just as to the radiology and medical. We already had a time limit on the billing. So if I'm understanding right, we need to pay and reissue. We need to have our records vendor redraft those for medical and radiology to be 3 years back from the date of incident. But billing can proceed as drafted. Is that right?
I think that sounds reasonable. Do you, Mr. Rudder?
Am I hearing you correctly? You're saying billing can go back 5 years or what?
No, Mr.
She's already given you those.
Yeah.
The billing is already just June 11th, 2021 forward.
Okay. I'm fine with that, Judge.
Okay. Anything else? Do we have another motion? I don't know who got y'all to be able to get on this docket for an hour. Okay.
I don't know.
Maybe you could ask for more. I don't know. So we've done everything then. All 4 items.
All 3. Yes. Yes, Your Honor.
Right. Okay, I just want to
Yep.
make sure, I got to read a
Sure.
lot of stuff all day long every day, and we just got out of the jury trial, so it was fun.
Oh, wow.
Though. It was fun, I mean, it's fun for legal nerds, not for some, but because we did get a verdict, so
Awesome.
yes.
And then it was gone. And then the videos, and watch, this is what happens, okay? The video is unavailable. I what a crazy case. This court is crazy. Thank you all for being here. We are the legal nerds. We are like seriously. Trish, you're so cute. Oh wait, I'm gonna make myself all bigger here. That's so sweet. I am thanking you all for being here. I really appreciate it. I would love it if you would make sure that you've liked the video. If you want, what I would really love is if everybody in here would go ahead and comment on the video tonight. Just true that. Just that. That would be the best. If we had like maybe 10, 15 comments that just said true that, that would make me really happy. Jim, I saw that you had a bad oncology appointment. I'm sorry to hear that, friend. While I am stepping out now, I know that People in Court is live right now, so please head over there to hang out. It's a great chat over there as well. The world's best traveling chat. Thank you so much. Prissy says, have a great date. Do all the things you're too chicken to do, but be safe. Oh, I'm always safe, girl. And I'm never chicken. Never, ever, ever. But seriously, guys, that was fabulous. And Daylight, you were asking, that was in Travis County, the 455th District Court of Travis County. I will do my absolute best to catch the rest of whatever we can with that. I don't know if, no, I don't, she hasn't turned it on, I don't think. I don't know how to do that, but I love you guys so much. I know, but Deborah, your commentary is so helpful because you're telling us what the real stuff is, and the judge is over there like wrong. It's crazy. Anyways, allegedly, in my opinion. Does that cover me? If I just say allegedly, in my opinion? Folks, I love you. I'm proud of you. And I will see you tomorrow. That was Judge Madeline Connor in Travis County, Texas. Please don't forget, true dat, true dat, true dat. I love you. True dat.